Right. Second time, seventh time I'm mentioning prior to change the determination, it was appearing in the
No, application for
appropriate order and for substitution.
substitution application. Anyway, it will appear if the records are here. Please give it.
Finally, my lord.
Yes. Yes.
My lord, may I permit to mention restoration application?
Yes, give it.
Any.
Yes. Application, yes.
My lord, may I be permitted to mention a matter, my lord? This was already fixed on 16th of July at 3 p.m., my lord. However, my lord, the honorable bench was not in motion on that day, my lord.
Okay, it will appear as to be mentioned.
Has to be mentioned.
Lord,
Yes, great.
to be mentioned, I have also mentioned earlier.
Yes.
Order that's it.
Check is
Order done.
lying with me. Now, one for correction and one for extension of time.
Yes, to be mentioned.
One is here. One is filing here. Kindly take it and file it.
So have you recorded, mentioned that file is here in the court?
Yes. Another matter application first year.
Yes, give it.
Permitted to mention one matter for extension of interim order.
Yes, to be mentioned. Have you served notice to the other side?
Served.
Yes, serve it.
Your Lordship, may I mention one matter for upgradation? It is running in
Just wait, it is running in the list.
It's
Yes, outside the list first.
For inclusion, your lordship.
Inclusion under what heading?
Application.
Application for?
Lordship for orders.
Application for what?
FMA, lordship.
No, what application you have filed? What?
For orders.
Can application. Is there any can application? Yes, give it.
Lordship, may I permit for application? One is there are two applications. One is occupational charges, and second is the maintainability of the suit.
Yes, give it.
My lord, may I permit one application, stay application for inclusion. my lord.
Yes,
I have
give it.
given notice.
May I permitted to mention, my lord? My lord, this is an inclusion on the heading to be mentioned, my lord.
To be mentioned for what?
For inclusion in the list.
No,
my lord.
hearing matters.
Matter.
Claim
Yes,
case.
Heard, my lord.
Matter was heard earlier.
My lord.
Okay, to be mentioned.
My lord. My lord. Another matter is running in the list under.
So wait.
My lord.
Outside the list, let it wait.
For inclusion in your lordship's list, I am appearing only the claim respondent claimant with the leave of the court.
Okay, hearing claim case.
With the leave, with your lordship's leave, I shall file my lord paper book.
No,
Paper
no,
book, I have prepared the paper book.
no. Paper books is filed.
No.
Paper books are ready.
Ready.
So you want the matter to be included under the hearing.
My lord, I want to first, my lord, I shall have to file the paper book. Because
Whatever it is, if the paper books,
to be mentioned,
if the paper books are ready, the matter can be included under the heading hearing.
prepare the paper book.
Yes.
Not been filed.
Very well. You file it at the date on the date of hearing. So let it appear for hearing after 2 weeks. Hearing. Yes, after 2 weeks. Yes. Yes, after 2 weeks.
Lordship, may I permitted to mention one application and 3 hearing for claim cases. my lord.
Yes, hearing matters after 2 weeks.
And one application.
Yes, application will appear. Application. Yes, give it.
My lord, one application, second appeal in connection with second appeal. I have mentioned, this is the third time I am mentioning. File is before your lord.
Application for stay.
No, my lord, section 5.
Yes, give the slip.
I am giving the slip. This is the third time I am mentioning.
Anyway, mention that. Mention in the slip. File is lying in court.
File in lying in this code, my lord.
Yes. Yes, give it.
Your Lordship, may I mention one matter for inclusion in the list? Paper books are ready. It is to be filed.
Hearing.
Hearing.
Yes, after 2 weeks.
I shall give the.
Patient 209, my lord.
Yes, any other matter outside list? Yes, listed mentioning
209, application, my lord.
200.
Issue company only challenge my lord delay as per paper book speculation. Action occurred 2016, my lord.
209.
Yes, my lord.
This is a 2026 matter. Just wait for few days.
My lord, item number 44 of my lord's today's list matter is item is listed as to be mentioned. My lord, what happened, my lord?
Item 44.
44, my lord.
Yes.
What happened, my lord? The appellant had died. I am for the respondent. I have.
Anyway, you move when the matter is called on. To be mentioned will be taken up.
Oh, very well.
Your Lordship, item 122 of your Lordship's today's list. I'm mentioning for upgradation, your Lordship, the matter is
122.
122. I'm for the respondent, Your Lordship. The matter is ready. Even written notes on arguments have also been filed. The matter was heard for a day.
Heard.
It was heard for a day.
Acha, let it appear as to be mentioned 122.
Gratefully, Lordship.
My lord,
122 to be mentioned at the other way. Yes.
for 93
The
of the
other-
today's
Other
list,
side-
my lord.
93.
93. Under
Yes.
first matter under the heading hearing, my lord.
Yes.
That has already been heard and the date fixed for only to file the written statement, written argument, my lord. This is the last order, my lord.
So both parties were heard.
My lord,
Okay, let it appear as to be mentioned.
my lord.
My lord, 156, my lord. And so company filed a petition for CAN.
156. Yes.
CAN already pending, my lord. Insu company name has been changed, my lord.
Item 156, it is appearing under the heading application.
My lord, CAN
No, it is appearing under 156. Yes, let this matter appear under the heading application. 156.
Your Lordship, in item number 10 and 11, I am praying for only not today because this is that matter, DRT matter, where Mr. Arindam Banerjee, senior advocates, are making submission. He is not come to court, he is not well. That's why, Your Lordship, I am praying for not today.
Okay,
Let
not
the-
today.
Both these matters appear tomorrow in Your Lordship's list.
No, only just not today. On the civil revision day, it will be taken up.
Your Lordship, and made retain its position and another Your Lordship submission. This matter has been made part hard. In the list, it is not appearing as part hard, Your Lordship.
Anyway, on the next day, I shall see. Let it be not today.
Quickly apply.
Yes. You are for the petitioner.
Yes, ma'am.
Yes, what is this application for? Can 2? Can 2 is your application? Oh, dispose. Okay, not today. Same. Yes. 14. Your application for restoration?
My Lord.
Yes. Okay, short passover.
Then, my Lord, make it not today, my Lord.
Okay, not today.
Lordship, this is my personal matter. I am being led by Mr. Operative Putra. I'm praying for a short passover, Lordship.
Okay, passover.
Can give in. দিয়েছি তো কালকে দিয়ে গেছি না থাকলে আবার দিচ্ছি আছে তো
I'm here.
Oh, okay.
But one thing I'll just, she's appearing in person, but I'll just indicate because other courts have also asked and because this is pertaining to two lawyers.
Okay, personal matter. So it's better, you see, try to settle it before mediator. I'm referring to mediation.
So there is a decree that's been passed by this division bench of this court, been going on for a very long time. There's no chance of mediation.
No, in execution stage also there can be
But
mediation.
here there is absolutely no way that the parties can mediate. The decree has been very, very difficultly obtained, the decree of the division bench. In fact, the restoration application which is now appearing.
He has reached his finality.
Yes. Decree has been passed, execution is pending. And the application that is there, which is appearing as not found, well, that is not there on board at all. So probably records will have to be reconstructed and then it will have to be taken up.
No, the main revisional application is to be heard out now.
No, main revisional, it's become infructuous. Main revisional application is challenging an order passed in the suit where the jurisdiction of the city civil court was questioned.
Yes.
That application was dismissed. He preferred a revision. That revision was allowed to languish here. The suit thereafter culminated into an order. From that, we prefer an appeal, and now a decree has been passed. The suit is
So
gone.
what is the scope of revisional application
That's
now?
right. That's what I'm saying.
The thing has become infructuous.
But there is a restoration application that is pending. This matter was filed in 2013.
So let us do one thing. Let us restore the matter and pass the final order.
Not for that's right.
Yes,
For
that will be
I think Mr. Mitra appeared on one occasion.
Yes.
Yes, Mr. Mitra
yes.
appeared, and I recollect that the matter is dismissed for default.
Correct.
So-
Your Lordship is right. Now that the application is not on board, I think your Lordship's officer was favored with a photocopy. That's probably not the procedure. he'll have to reconstruct the records and come back. Otherwise,
Only with the can? No, if it is
only
only.
with the can. Only with the can. He'll have to reconstruct it. Otherwise, your lordship can't be expected to pass an order on a photocopy of an application.
So let the records be reconstructed. Yes, record an order. As the application can,
Restoration. Only
as
for
the
restoration is
application
missing.
can, restoration can, what is the number?
One.
1 of
13.
2013 is not available in the records. Let the records be reconstructed and the same be put up on ten 8/2026. Yes, along with the main application.
My lord, I am for the petitioner. My lord, kindly give.
What is this application? Can 1?
That is the dismiss for default restoration application.
Okay, can 1 and can 2?
Can to my application filed in 2018 for expeditious hearing.
Okay, let us take up this can 1.
My lord, kindly allow the restoration application.
My lord, your lordship, can see paragraph 3 of the restoration.
Okay, have you filed any opposition to this?
Nothing.
Okay, let me see. Can 1 of 2018.
Can 1 of 2024.
Hey, can 1 of 2024 ta din. Yeah, 8 না এ তো can 2 এটা can 1
18 তো 18 আমার application can 1 তো can 2 টা আমার can 1 টা restoration
হ্যাঁ can 1 respondents.
Your lordship, can see paragraph 3 of the restoration application. No ground is there.
No, this is application for expeditious hearing.
Yes, that is of 2019 my application. Your lordship may dispose of that because the matter is now in her.
What is this can 2? Yes, can 2 is the application for restoration. No, why do you say it has become infructuous?
My application up to 2018 because expeditious hearing. Now your lordship is hearing the matter.
Okay, so this matter be restored.
Restored to, I have strong objection because your lordship will come to paragraph 3 of their application.
Paragraph 3. So 11 months delay. About
Not only that, what is the ground of delay? Your lordship says only one line: the learned advocate for the petitioner could not appear due to some confusion. What is that confusion? And the matter is pending since 2011 at 12. And only
the order of dismissal passed 2023.
Yes, and after 11 months, my lord, they filed that application. So confusion continued up to thereafter for 11 months.
Okay, let me see which page is the order. Have you annexed this order? Yes. Yes, record an order. Learned advocate for the parties are present, learned advocates. The petitioner has filed this application for restoration of this revisional application, which was dismissed for default on 6/12/2023. Although learned advocate for the opposite party objects to this application, but considering the ground shown for the delay and not appearing on the date fixed, this court is of the view that in the interest of justice, this matter should be restored. Thus, order dated 6/12/2023 dismissing this revisional application CO 2991 of 2012 stands recalled, and this application CO 2991 of 2012 is restored to its file and number. Let this matter appear for hearing on. I'm keeping it on 10th of August. After 2 weeks.
No, 1 week. I am ready even today.
Okay, let this matter appear on 7/8/2026. So come ready on the next day.
My lord, my lord. My lord, on that day, we have just missed the number.
Anyway, next day come ready.
My lord. Grateful lordship.
I'm for the petition.
17, my lord, Mr. Arif Ali is appearing for the opposite party. Now, I'm praying for short passover, my lord. He's on his leg.
Okay, pass over.
Come on.
As well, Lockheed Arsenal, I prepared a list of dates.
There is a claim case filed by my learned friend. But your lordship kindly protest, my lord, against any order passed by the tribunal, my lord, appealable order. Revision does not, your lordship kindly peruse section 23.
This is not against the order of, it is not award. This is not against an interim application. Order passed in on an interim application.
Award was passed on 13/5/2010.
13/5/2010.
Okay. Then
my lord, before that, not on Sepalidas died. The
when
number one died on 3rd of February 2010.
3rd of February 2010.
Before the date of my lord award.
Before the date of award, but was the hearing concluded at that time?
Hearing, evidence concluded, hearing concluded, but judgment was reserved. But evidence concluded on 12th of August 2008.
And okay.
And said that deceased person, my lord.
Oh, when was the arguments concluded? Okay.
Well,
3/2/2010, Shepalidas died. When was the argument concluded?
Argument concluded prior to that.
When?
That date is not with
So
me.
let the trial court records be called for. Yes, record and order. Learned advocates for the parties are present. Let the trial court records be called for at the special messenger cost of the appellant. Let this matter appear on 24/8/2026. Let this matter appear on okay, 20th August 2028. 20th August 2026. All points are kept open.
19, and for the opposite party number 1, my lord. My lord, opposite party number 1 has applied for some certified copies before the learned trial court, which he had not obtained till now, my lord.
No, you are for the opposite party.
Opposite party number.
So what is this application?
My lord, I am praying for 2 weeks accommodation.
Oh, you are contesting this matter. So what do you want? Certified copy?
Yes, my lord. The client has applied for some certified copies of the orders, my lord.
Some
Which he has
certificate
not
copies we
obtained.
have obtained. If both are same, then we can produce that. Whatever certificate copy they have obtained, they can tell us. Some certificate copies.
Certified copies of the order of the trial court or this court?
My lord, actually, the certificate copies of the on the last occasion, Lordship had asked us for some documents which neither lying with us, not lying with my learned friend, Lordship. So perhaps both the parties have applied for certified copy of those documents.
Okay, let it appear after 2 weeks. Yes, learned advocates for the parties are present. Hard learned advocates, let this matter appear on 10/8/2026.
Lord, one is Lord, my revisional application, one is my learned friend's revisional application.
For
Both
the petitioner, my lord, in CO number, my lord, 3731.
both from the same order. Lord, I just indicate. my
This
lord,
is your application.
Yes, my
Two
lord,
applications are there.
3731 is my lord revisional application filed by the my lord, my client,
The other one is yours.
Correct.
challenging the same
Same
my
order, same order.
impugned order.
Suit for Lord, eviction. Lord, these two revisional applications, Lord, from a 7-2 order. Lord, sorry, 17-2 order under Lord, the old act. My lord need not look at the records, not at all look at the records. My lord, there were my lord, two parts of the rent. One was rent, one was my lord, maintenance or amenities charges. There are two plaintiffs. My lord, this is my lord, a unique feature in the suit. There are two plaintiffs in a suit for eviction. My lord, one used to get the rent. My lord, one used to get the maintenance charges. Both were my lord, components of rent. My lord, that is our case. My learned friend says maintenance charges, since that was being payable my lord, to someone else, to the plaintiff number 2, he can't be my landlord in true sense of the term. So that's his contention. Now, my lord, we are on the quantification of my lord, the ADR rent under 17.2. My learned friend my lord, has accepted one part of it, which is payable to plaintiff number 1 as rent, not maintenance charges. My lord, this is a contested matter. My lord, will take time, my lord, for getting hurt. We can understand that. My lord, there is a direction upon us, my lord, to use an affidavit, upon both of us to use an affidavit indicating the extent of the property let out. My lord, we don't have an access, could not, my lord, file an affidavit. I have, my lord, advised my learned junior to file an affidavit to the extent, my lord, we can assist your lordship with regard to the extent of the property let out. No difficulty. My lord, the amount which they are admitting, my lord, let that be paid in the meantime. There should not be any difficulty in paying that. So far as the my lord, disputed party is concerned, my lord, this revisional application would be taken up, my lord, hard, adjudicated by your lordship. That will take time.
For that, did you file any application
My lord,
to pay the admitted rent?
My lord, if my lord want request.
Well, what is this application? Can one?
And one, my lord, is basically an application wherefrom my learned senior friend has prayed, being a landlord, that I should pay the, my lord, whatever the property tax so far as regards my occupied portion is concerned. Now, if your lordship looks at the 1st August 2022 order, the coordinate bench of your lordship's court, upon the prayer of the lord plaintiff, granted a leave to file a supplementary affidavit to show what is the accommodation
extent of property let out.
Because why, my lord? According to my learned senior friend at that juncture, what he is suggesting that this much area is under my occupation, that is not, my lord, apropos to the schedule of the suit property as per the plaint filed by him. That's why at that juncture, the coordinate bench of your lordship's court directed him to file a supplementary affidavit as per, my lord, if your lordship
upon both.
So that is done. The supplementary affidavit is not filed.
Has my lord filed an affidavit. My lord, I could not because I do not.
Against that, you want to file any rejoinder?
That direction was also there. Thereafter,
My lord, I am not on this, my lord, part of municipal charges today at all. I am not storming my brain, my lord, on that at all. My lord, there is an admitted amount which is, my lord, admittedly lying payable by them. They have admitted.
How much it is due and payable now?
4,000 per month was, my lord,
No,
the rate.
till now, how much is due and payable?
My lord, that, my lord, I can, my lord, make a comprehensive table. It's since 1998, 4,000 per month. 1980, September 1980, 4,000 per month. So, my lord, what is accumulated today? That, my lord, my learned friend's client and, my lord, his counterpart, my lord, has agreed before the learned trial court to pay. My lord, that much of money
That I
should
shall
come to me.
consider on the next day.
yes, my lord, let me, that's for the first time, my lord.
Yes, learned advocates for the parties
There
are
should not
present.
be any dispute with regard to that.
Hard learned advocates.
I'll come up, my lord, with a my lord, comprehensive
The
calculation.
supplementary affidavits which were directed to be filed earlier are filed by the parties.
My lord, I have already, my lord,
My learned friend has filed.
Rejoinder, if any.
No, not required.
Okay.
Not required.
Let this, which was directed to be filed by earlier order, be filed in the meantime. Let this matter appear on 10/8/2026.
If my learned friend is suggesting that there is an admission on my part,
I'll indicate that.
I shall consider the record. Yes.
Lord, if there is any admission, Lord, on my part regarding payment, Lord, I will have to look at the record. So, Lord, keeps up at least 2 weeks after. Lord,
I'm giving it after 2 weeks. 8th of August.
10th of August.
Sorry, 10th of August.
10th of August. Very well. Very great.
Grateful.
Great.
20 to 23, my lord, I am for the petitioner.
Item 22.
I'm for the petitioner, my lord. This is the affidavit of service.
Yes.
22 and 23, my lord. This is the affidavit of service for 22.
Okay. This is application for?
My lord, recalling restoration for dismissal of default as
Two, I appear on behalf of respondent opposite party number 5, 7 to 18, 25 to 31 and 33.
You are appearing for?
Well, I tell you, Lordship, my lord, so far as the restoration application is concerned, there is a restoration application along with an application under section 5. Restoration application, I am the last person to oppose. So far as the delay, there is a substantial delay, but be that as it may, my lord, Lordship may allow. With regard to that, I do not say anything. But my lord, with regard to the matter, that is the main revisional application is concerned, only order which can be passed is an expeditious disposal of the matter before the learned trial court. Nothing more can be done.
With great respect to my learned senior, main matter, kindly fix a date, kindly allow the restoration.
Anyway, let me see the restoration application.
Yes.
Can?
This is
Can 1 and
my
can
lord,
2.
Can 1 and can 2. There are
Can 1 for restoration, can 2 for section 5.
Can 1 টা কোথায় আছে? Oh. How many days delay in
There are,
78 days delay in filing the restoration.
So there are 34 opposite parties. You are representing?
I appear, my lord, on behalf of my lord, 5, 7 to 18, 25 to 31 and
5, 7 to 18. Yes.
25 to 31
25 to 31
and 33.
and 33. Almost all are represented.
Yes, yes. Yeah, with regard to section 5 and the last person, my lord, though there is a substantial.
Yes, you are appearing for?
My lord, my learned friend
Okay,
is
okay.
appearing.
But 22 and 23 item numbers, both are connected matters. This is 22. Same party, I think my learned senior friend is appearing for them.
Yes, record and order. Learned advocates for the petitioner and learned advocate representing respondent opposite party number 5, 7 to 18, 25 to 31 and 33 are present. The affidavit of service file be kept with the record. The service of notice upon with regard to section 5 upon the other opposite parties is dispensed with. The application for restoration is taken up for consideration. Heard learned advocates peruse the petition for restoration and condonation of delay. Upon perusing the petition and upon hearing the learned advocates, this court is of the view that the petitioner has been able to furnish sufficient ground for not being present on the date fixed, as well as the ground for condonation of delay. Thus, delay in preferring this application is condoned. Order dated 1/4/2024, passed in CO 3512 of 2018 is recalled. CO 3512 of 2018 is restored to its file and number. Let this matter appear on 10/8/2026. The respondents who have not appeared today be served once again.
So only notice intimating the next date of hearing.
Yes, no. The service, original service was done.
That was admitted initially.
No, application was not admitted.
No.
Miller, kindly, I cannot make a comment, Miller.
It has been admitted by Justice Sanjeev Banerjee as his lordship then was.
What is the order? No, as because you see, respondent opposite parties are represented. So unless it is copy served, how your learned friend will appear? No, was there any caveat in this matter?
Caveat?
No, you are appearing pursuant to service.
Miller, I tell you, Lordship Miller, so far as my client is concerned, he has served me a copy of the restoration along with the section 5. Also, Miller supplied me a copy of the original application.
Anyway, serve once again. Either the parties or the trial court advocate. Matter will appear on 10/8.
Next item same. My learned senior is appearing.
Next also same.
Same parties.
Next,
same parties.
Next house same আছে. Okay. In the next matter?
Next matter.
No, but the application is for restoration.
Yes.
How many respondents are there in this matter?
34.
We are appearing on behalf of 5/7/18.
দুটো আলাদা কেস কিন্তু পার্টিসটা ডিফারেন্ট অ্যাপিয়ারেন্স ফর দ্য different parties. So learned advocate for petitioner and learned advocate for respondent opposite party, please give the numbers.
On there, minor two application or five. One application, and one application for expunging the name of the opposite party number one. And second, minor substitution application, which is within time. Well, can number three, petitioner number one died.
What is can 1 of 2019?
One petition application for expunging. Expunging the name of the opposite party number one.
What?
Opposite party number one. You died by Lord 2016 and revisional application is 19. Due to lack of minor not proper instruction, Raspberry was made party.
So actually you have filed this revisional application against dead person.
Against the my lord, dead person, my lord, Raspberry already application was made before the trial court.
No, question is this.
Yes.
This
For that reason, my lord, expunging, my lord.
This present revisional application, that is this CO 525 of 2019 is against dead person. One of the dead person.
One of the dead person. And
Yes.
my question is whether the Raspberry Jana has already been substituted in the trial court, that instruction is required to be taken note of.
But I have stated, my lord, paragraph number 3.
No particulars.
No particular, but my lord, dear Justice, yes, invite, my lord, you lost only 2 and 3 paragraphs.
Yes, Mr. Mahato is representing all the respondents.
But my lord, so far this instruction, whether Raspberry Jana died and on his
Okay, let me see this application.
Yes.
See, on paragraph 3.
Paragraph 2.
2 and 3. Yes, ma'am.
Yes. Shankar Jana.
Due to lack of proper instruction, the
Okay, Shankar Jana died on 12/4/2024.
Shankar Jana.
Yes.
It is a Raspberry Jana, my lord.
So, petitioner number 1.
Yes.
My lord, I am appearing for not for all. I am appearing for the respondent number 4, 5, and 6.
Shankar Jana, my lord. Shankar Jana died on, my lord, 12/4/24. And my lord, application was filed 10th July 24. Within time.
This application may be allowed, but difficulty is, my
What
lord,
is the other application?
unless the earlier application is disposed of, it is the revision application is not regularized. My lord, no order should be passed.
Where is
If you
this?
should kindly take it one next week, my lord, I shall take the instruction and my lord, sir. Both the application will be disposed of.
Yes, take necessary. Yes, let this matter. Learned advocates for the parties are present. Let this matter appear on 3/8/2026. Yes, next Monday.
These are my applications. Lord, additional applications. These are arising out of an execution proceeding.
Yes, that second appeal is pending.
Yes, second appeal, your lordships have sent it to mediation.
Yes.
But I am told, I don't know whether the report has come.
It will come on that particular day when the second appeal matter is fixed.
I কবে 10th কবে আছে কোথায় গেল কবে এখানে আসুন না স্যার সেকেন্ড অ্যাপিল কবে ফিক্স আছে But I think 10th or 11th August, I am not sure. Let me just check.
My lord, my instruction is the mediation did not succeed.
We see if there are any report is there or not.
Yes, the report has to come.
Report has to come. Success, no success, there should be a report.
Yes. And mediation has been sent in the revisional applications.
No, no.
No.
Second appeal again.
Second appeal.
In the second appeal.
So when is the date fixed for second appeal? I shall keep it on that particular day.
Right now, I am not in my advocate on record. He has not come.
My advocate on record is also not there.
Just give me a second, but I'll tell your lordships the date.
I just make it not today.
Lord, what I'm saying is, I'll tell your lordships the date, Lord, when the second appeal is made returnable, and my lord may keep this together and extend the interim order in these two matters.
My lord, lordship will not extend the interim order because the execution proceeding is in September.
So,
and lordship, yes.
How does that matter? The interim
Yes,
order
no.
was extended, reimposed.
Lordship
It's
will
expired
not
on
be
8th
extended.
July.
Can you come with instruction? I'll keep it next week. Just making
Yes,
not
yes,
today.
yes. Nothing will happen in between.
Lord, kindly extend the interim order.
Lordship will.
When will it expire?
Lord, the interim
It has
order will
already
expire.
expired on 8th July.
I'm going out of
No,
court. Let him argue. This
no
sort of
application has
thing
been made.
No,
Application has been made. It has expired on 8th of this month. No mentioning, no application, nothing has happened.
When is the date fixed for execution?
It is in September, middle of September.
Lord,
You
if
have
he's-
that order.
Lord, if he is done, I'll argue. Lord,
I can find it out. And lordship, for second reason why lordship will not be extending the interim order, because any stay of the execution, my learned friend's client will have to comply with the order passed by the honorable division bench while admitting the appeal.
Lord, if
Nothing has been
What was the order? To pay
Order was
occupation charge?
occupational charge,
Lord, if I
area rentals, and a lump sum amount. Only the lump sum amount of 4 lakh has been paid. 25,000 was ordered to be paid per month from 2018 onwards. Not a single dime has been paid. He's enjoying the property free.
Lord, if he's
So you can apply for vacating that order.
By non-compliance itself, there was no interim order passed by the learned trial court.
Lord, if he is exhausted, then I'll say.
When is
Because
the-
now,
Anyway, just
now it's a trend, Lord. The respondents speak first in court. Now,
let this matter.
Lord, only 1 second. Can you hear me? I was for the petitioners. The respondents now, they speak
You
first.
see, whatever it is, let me go through the report.
Yes,
It's the second
not only-
appeal.
My lord, I will
not extend the interim order.
But you want to execute it in the meantime.
No, it's in September.
Okay. Acha, record an order.
Lord, may I just
Learned
get
advocate.
2 minutes audience, my lord?
Yes.
May I just get 2 minutes audience? I hope he has done. Disturb করবে নাহলে বলবো না, তুমি করে নাও। So, my lord, this is the habit now. My lord, the interim order has been reimposed by your lordships. The interim order, which was passed in these matters, have been reimposed by your lordships after a contested hearing where he was present. Reimposed by your lordships. Then he did not take all these points. Now the matter was appearing before your lordships. The matter could not be reached by the court. Your lordships was sitting in the division bench some days on the Mondays, my lord. So 8th July, the interim order has expired while it was being extended, reimposed by your lordships. So today, whatever submission he is making, perhaps he is either without instruction or he doesn't want to tell the correct fact. Your lordship, kindly, I don't have the right order. If I get the file, I'll find out that order. Your lordships have reimposed after a complete hearing him. What is he saying today?
There was no hearing
Oh,
on the
just a
interim
minute. Earlier there was a direction. Let the two matters appear along
Yes.
on 6th
With the
July
appeal.
2026.
And it did not appear.
It did not appear.
দেবুকে বলো না অর্ডারটা পাঠাতে কবে রিইম্পোজ হবে, দাঁড়িয়ে আছো কেন? Please send me the order when
I
it was
keep it
reimposed.
this coming Saturday, 1st of August.
Saturday, my lord, I have a matter in the commercial court. I did not know that court will function. Keep it on
Let
next
this
month.
matter appear along with SA 93 of 2016 on
This was your lordship last order. এটা রাফে আছে এটা দাও।
on 10/8/2026. Interim order granted earlier stands extended
Lordship will not kindly extend it.
for a period of 3 weeks or till
Yes,
further
will
orders,
not extend.
whichever is earlier.
Lordship, I want urgent certified copy of this order.
Very well.
Yes, urgent certified copy.
This is a new trend. Again, a new trend.
Whatever is the trend, because lordship
doing
there is
Maintain-
they have not
maintain
obliged,
some
they
dignity
have
of the
not,
court.
they have
Maintain
not
some dignity of the court.
obeyed the order of the Honorable Division Bench.
For that you take steps.
No, there is
Lord,
no
order
interim
21
order.
rule 97 filed after 2 years.
There was no interim order.
That is under challenge.
Anyway, come on 10th, I shall see.
My lord.
Urgent certificate copy.
Yes.
Let's start.
Item number 27 and 28, my lord.
I'm for the petitioner, my lord. I'm praying for 27 and 28, not today, my lord.
27, 28, yes, not today.
That will be I appear for the petitioner, my lord.
Lordship, in this matter,
So I'm for the response. I'm for the opposite party.
The matter, the hearing was concluded and well, the parties were directed to file a written notes of argument.
29 hearing is concluded.
Lordship, may I indicate?
My lord,
Lordship,
before Justice Sharma,
No, did I hear this matter? Then I,
a written notes of argument has been filed.
may I
whenever it is, I have to hear the matter, then
My
ask
lord,
for
my
written
lord.
notes of arguments.
Lordship, only for that purpose, on the last occasion when this matter came up before your lordship, time was sought for by the petitioner. We indicated if your lordship would be pleased to fix a date. Lordship, we are urging that only. If a date could be fixed, sometime in next week, on the
Lord, I am
4th,
out
Monday,
of possession in spite of getting a decree of eviction. My lord, since my lord, this
nothing
petitioner
changes.
application.
Oh, question is, anyway, I'm keeping it on Monday, but come ready.
monthly list day, lordship.
No, coming Monday, I'm keeping this matter.
Coming Monday is a monthly list day. If it is
No, whatever it is, it will appear.
Take one adjournment on my personal ground.
Yes.
They have taken so
Record
many
an
adjournments.
order.
Yes.
Learned advocates for the parties are present on the prayer of learned advocate for the, you are for the petitioner.
respondent.
No, I'm for the petition.
For the respondent, the matter stands adjourned till 3/8/2026. Acha, 10/8/2026 as the last chance.
Lordship would not indicate as last
No,
chance.
my lord, this is
because
peremptory. No, my lord. My lord,
no.
my lord, kindly have a look to the order sheet.
nice
They have
of the
taken
order.
so many adjournments.
It's like we have been taking order.
No,
but
my
if the records
lord, they have taken.
on the last occasion, they only.
Otherwise, you see, there will not be any initiative.
My lord,
Lordship,
my lord,
we will
before
be
Justice Sharma, they have taken so many adjournments, my lord. My lord, since my lord 2019, my lord, I am out of position. In
No,
spite of
you have to
getting
come
decree.
ready on next day. Yes.
We will definitely just that.
No, my
that
lord, this
day-
No. It is
direction. My lord,
required.
let it be, my lord.
Lordship is
Direction.
keeping out
10th of August.
10th of August. Much obliged.
I am deployed.
Shanti matter on behalf of the opposite party plaintiff.
Yes.
Lord, I think you appear question. And my lord, may I tell one thing, my lord, the upper notice to the my lord, the revisionist petitioner, who is the my lord, the dependent therein. Now, my lord, the revisionist petitioner, my lord, they filed the revision petition and they are enjoying a stay order. Stay of my lord, the hearing of the suit. And my lord, what happened since my lord 2019? Now, my lord, I mentioned the matter before your
This matter has to be heard out.
matter has to be heard. Now, may I lordship, my lord, on the last occasion, my lord, in presence of the learned advocate for the petitioner, matter was taken up. But my lord, the matter was, my lord, the adjourned because of the fact that let them, my lord, take some time. They prayed for time. Now, my lord, humble, my lord, submission is that this matter, my lord, this matter can be disposed of, my lord, within a maximum 10 to 15 minutes. My lord, if your lordship allow me today, my lord, 5 minutes time, my lord, I can tell before your lordship why. My lord, I have
My lord,
filed,
prayer for him
my lord,
password.
just
My
a
lord,
minute.
sir, password on-
Now, my lord, may I tell? Now, my lord, I filed the suit, my lord, praying for my lord the possession. Now, my lord, suit arising out of a my lord the agreement for my lord the sale of a particular property. Now, my lord, I handed over the possession pursuant to the terms of the agreement that upon payment of a lump sum amount, the part of the consideration amount, possession can be given, but my lord, the execution of the my lord the sale deed should be within a certain period upon payment of the balance consideration price. They did not turn up because of the my lord the obtaining possession. Then my lord, after about my lord 7 or 8 after my lord sending so much letters, then we terminated the agreement and we filed the suit for possession. Now, my lord, after about my lord 8 or 9 months, my lord, the defendant number 1 filed his written statement. There, my lord, the acceptance of written statement is pending because of the fact that it is, my lord, after my lord, the so many months, not within 90 days, not after 30 days. Now, my lord, they have to answer there.
Now, what is the order? Let me
Order.
under challenge.
My lord, order me, I tell. Now, my lord, what happened, my lord? My lord, along with my lord, the written statement, counter claim also filed, praying for my lord the specific performance of degree. Lordship, kindly consider specific performance of degree in
Of
their
contract.
Yes. Now, my lord, that my lord counter claim and the written statement rejected by the order impugned because of the two grounds. Counter claim, my lord, we filed an objection because lordship knows that counter claim otherwise is an independent suit. That should be, my lord, within the period of limitation mentioned in the articles of the Limitation Act. And my lord, that should be within 3 years.
So this is a purely question of law.
Purely question. Now, my lord, the counter claim rejected because of the fact not beyond limitation period. That is pending. But the written statement that counter claim rejected on the ground that the defendant number 2 did not turn up so long, but the written statement filed.
Written statement is accepted, counterclaim is rejected.
I'm coming. Written statement filed jointly by defendant number 1 and 2, along with, my lord, the counterclaim. Now, the court said that when the suit was running, my lord, for my lord, ex parte hearing against defendant number 2, who did not turn up so long, so why shall I accept written statement and counterclaim along with that defendant number 2? And, my lord, several, my lord, the show causes were given to answer the show cause, did not file any response to that. Now, my lord, may I tell, lordship, kindly, my lord, may I tell, this division petition can be disposed of, directing that the defendant number 2 be given liberty to file his, my lord, the answer to that so cause why ex parte hearing should not be, my lord, the.
Just a minute, let me.
Yes.
That is order dated.
Mother, there's a list of dates. If you lordship, only orders, mother, very short list of dates.
Give me a short passport, my lord, and Mr. Borden is engaged.
Mother, after enjoying, my lord, lots of enjoying of that, my lord,
The order under challenges. Okay, for filing written statement by defendant number.
Let's kindly have a look. Only 2 dates. My lord, the order date 26th of March and the order, my lord, followed that. 2 dates. Only 2 dates. 26th of March.
Order dated.
These are the, my lord, the impugned order 26th of March, and then that was followed by 10th of July. Entire proceeding stayed, and they are enjoying because they are in possession. And since 2019. And now they are coming and say every day, last occasion, today, the accommodation be given.
No, the conduct of the parties is to be looked as a whole.
Suit filed in 2015. Yes, I'm grateful to my learned friend. During the period from 19 to till date, matter is.
Let me see the rejection, order of rejection.
Rejection is, my lord, that should
That
be
is the
26th of March, 10th July. 10th July. Because 10th July, my lord, the list of date, page 4. And 10th July order is at page. My lord, the certified copy, the last page. তো কাগজ জুড়ে দিয়েছে কেন এখানে?
Okay. (26/3/2019).
Yes.
Okay, 10/7/2019.
Yes.
So you were challenging what, 26/3/2019?
They challenged in the revision petition.
Yes.
My lord, both 26th of March 2019 and, my lord, the order dated 10th of July 2019.
So is kept pending. So the written statement was not accepted.
Written statement
Was not accepted, neither it is rejected.
Neither it is rejected. No, written statement rejected. Now, kindly have a look at, my lord,
10/7.
10 July 2019, Lordship order. It appears from the case record that the suit is on ex parte board against defendant number 2. Therefore, defendant number 2 cannot join with
Yes,
defendant
yes.
in filing WH without counterclaim, with counterclaim, without setting aside the ex parte hearing. Hence, the WS with counterclaim is rejected. So, WS filed jointly, and that is why both rejected for the time being because of the fact that the defendant number against defendant number 2, my lord, it was, my lord, appearing as ex
It was
parte.
appearing under ex parte hearing. So unless that ex parte order is recalled,
Yes.
the written statement cannot be
Yes.
accepted.
Now, my lord,
So that is why it was rejected.
Now, my lord, may I tell? It appears from the, my lord, the records that several orders passed, my lord, giving liberty to the defendant number 2 to take steps for removal of that expression that to appear as ex parte. My lord did not take step.
Very
My
well.
lord,
Now this is 10/7/2018. Here there is no observation with regard to counter statement, counter claim.
no, counterclaim, my lord, there is a, my lord, may I tell? My lord, there are other orders. If your lordship kindly have a look, my lord,
That
the
would be, my lord, 21st of January 2016. Kindly sees, my lord,
The
21st.
order under challenge is 26/3/2019
My lord, the two orders under challenge, my lord.
and
Just 26.
10/7/2019.
my lord, kindly have a look at the list of dates that I had, your over lordship. Only very short list.
My lord, may I have a copy of that, my lord?
নিশ্চয়ই দিচ্ছি, দেবো নিশ্চয়ই দেবো। My lord, may I, no, sorry, my lord, list of dates not, my lord, after that. My lord, the lordship kindly have a look. My lord, the certificate copy to দাও তো। না, তারপর till date. My lord, counter claim, my lord, the time to time, my lord, the matter appeared in the, my lord, the on the board for, my lord, the taken up the, my lord, matter with regard to maintainability of counter claim.
So here, so far this 10/7 is
Not yet
concerned,
taken.
10/7 is rejecting the written statement as because it was on the ex parte board.
My lord. Now, the whole question is, lordship, kindly consider one thing. Whole question is, first of all, my lord, that application or, my lord, if any, my lord, the response to that be given with regard to that, my lord, that removal of that expression regarding ex parte hearing, that step is to be taken first. My lord, my humble submission today, my lord, that let them take within a very shortest period.
That they have taken, what they have said, that a petition is filed by the defendant.
No, reply, just sir, আমি একটু বলে দিই, আমি আপনার এগেইনস্টে কোনো কথা বলছি না। হ্যাঁ, let them file, my lord, the reply to that so cause by the defendant number 2, that why that shall not be removed from the, my lord, the board of ex parte hearing. So far, defendant number 2 is concerned.
By the plaintiff, it is to be filed.
No,
It
my lord,
is,
the count, my lord.
no, ex parte hearing, that recalling is filed by the defendant petitioner.
Yes, ex parte, no. Against defendant number 2, against the defendant number 2, the matter was appearing for ex parte for not taking steps after, my lord, responding to their appearance therein.
Yes.
So that step they have to take.
To recall that order.
To recall that order, number 1. Repeatedly that, my lord, opportunity was given, they have not taken. Then, my lord, may I tell, after that, my lord, the written statement filed, it appear, both of them, my lord, after the time expired by the, my lord, the whatever the statute, and then, my lord, after the order, my lord, the notification by our High Court, that in exceptional cases, time may be extended.
Now, one thing you see, so far, the written statement with counterclaim is concerned, okay? The court wanted you to file an application for recalling that ex parte order. If that ex parte order is recalled, the court will consider whether your written statement as well as the counterclaim is to be accepted or not.
May I?
Yes.
My lord, would kindly take the trouble of taking, my lord, the order dated 21st of January 2016. My lord, this is the matter, my lord, in which, my lord, the petitioners were the defendants in the original suit. They filed the counterclaim.
21st
with
January 2016.
16, my lord. This would be order number 5, I guess, my lord.
Yes, yes, yes.
Right. Kindly seize, my lord. Defendants number 1 files WS along with counterclaim. But I say, my lord, this was in effect. A written statement can counterclaim by both the defendants. There was a typographical error, my lord, I'll admit this. But it was, my lord, filed by both the defendants. And I'll say this, my lord, kindly takes the trouble of, my lord, coming to the written statement. Sir, written statement, kindly, my lord, sees.
So did you file this written statement and counterclaim within the date fixed?
My lord,
No.
kindly,
That is the
kindly
question.
sees. Kindly sees
Okay,
the
okay. 21/1/2016 was fixed for filing written statement by defendant number 1.
Absolutely.
So are you defendant number 1?
My lord, I appear for defendant 1 and 2, both.
No, no.
I am defendant 1.
This is the petitioner is defendant number 1 or 2?
Both, 1 and 2.
You see, so far, you see, this order is concerned. This was 29/2015.
Yes, my lord.
This order was confined to defendant number 1. So, if the right to file written statement or counterclaim, as the case may be, was that of defendant number 1, to which the defendant number 1 has filed. Okay.
And
now,
I say, my lord,
your application.
No, my lord, I appear for both the defendant 1 and 2. Kindly seize, my lord, the written statement was a composite written statement filed by the defendant number 1 and 2. There was a typographical error.
My lord, may I tell? Whatever, my lord, their answer to this, that should be by way of a, my lord, an application.
My lord, may I indicate one thing, my lord?
For removal of that. Let him explain there.
My lord, may I indicate?
That, yes, defendant number
I
2
accept what a learned senior friend
Let's go by the record, okay? This is.
But trial court has to, my lord, trial court.
Take a decision.
Yes, has to take a decision with regard to them.
My lord, may I say this?
They have to take a step therein.
May I say this, my lord? Kindly keep
They
the
are not taking step. And that is why, my lord, the culmination of that is that the resulting effect is that the
My lord, may I put it this way, my lord?
That against defendant number 2, the matter is appearing on the, my lord, the
Ex parte board.
And you are, my lord, that the file this.
Now let me see the order where this the order that the directing the defendant number 2's case to appear in the ex parte board. Let me see that order.
That is, my lord, the. June. Order number 3, Lordship, yes.
Order number 3.
I think in my list of dates also mentioned.
Order number 3, my lord.
Order number 3.
Order number 3, okay.
Yes.
Files petition praying for time to file WS. Considered.
And it is
record
reflected in the
that AD with defendant number 2 returned after service. Okay. Service is satisfactory. Defendant number 2 is absent.
Yes.
Hence, the instance would be fixed for ex parte against defendant number 2. This is order number 3. So this order was passed in 2015.
I accept, my lord. I accept the fact.
Now, when did you file? Okay, just
I filed my written statement on 21st of January 2016. After
1st
this.
of January 2016. Okay, so the court you have filed the written statement, but you did not file any petition for recalling the ex parte order.
My lord, may I put kindly, my lord. My lord, my written statement was filed by both the defendant 1 and 2. I'll be very frank and candid. However, there, my lord, was a typographical mistake which says defendant.
Look at order number 4.
My lord, kindly,
my lord, let it. There is, my lord, grateful to my learned friend that order number 4 was, my lord, the object.
Yes, I've seen that for defendant number 1.
Yes, yes.
I've seen that.
Now, my lord,
so previous order, it was fixed ex parte. Okay.
I accept it, my lord.
So that order, if it is by mistake also, if it is by mistake also, that has to be rectified.
Accepted, my lord. So what my suggestion would be subject to what eventually falls from my lord. My lord, keeps this after a fortnight. In the meantime, we'll go and take steps, my lord, that will expedite the issue. On that date, my lord, kindly directs the learned judge in the court, my lord, to dispose of my application as expeditious as possible.
That can be done.
So
right
matter
now.
be kept pending, and in the meantime,
Can be done right now also.
I have no objection, my lord.
Recording my learned friend submission, and my lord can pass an order that, my lord, why only that? My lord, there are 3 steps are to be taken. So kindly consider. My lord, 3 steps are to be taken. First of all, my lord, this application is to be made, and that will be hard. Second is that, my lord, that whether written statement filed by the defendant till day whether that can be, my lord, accepted or not.
Lord, that has been accepted.
Not yet.
Yes.
Not yet. Not yet.
Do we have
Lord,
a
kindly
copy?
seize the.
Not
Do we
yet.
have a copy of the written statement?
Yes, Lord, page 25. Kindly
Page?
seize 25.
Page 25.
Yes, my lord. Kindly seize what I was indicating.
দেখছি এটা দেখি।
My lord, 25, my lord. Kindly seize. Defendant begs to state that. Kindly seize, my lord.
There are total 2 defendants.
Defendants.
They have to explain that why.
My lord, kindly, kindly, my lord, now seize. Defendant beg to state. Page 25. Kindly seize, my lord.
Defendants, okay.
Now, my lord, kindly take the affidavit page.
Affidavit.
Kindly take the affidavit page. Why I say, my lord, it was a typographical error, my lord. Seize the affidavit at page 37.
No, affidavit. Page 50.
My lord, page 37.
Page 37.
Why I say, my lord, it was a written statement by both the defendants. I admit the fact, my lord, there was a typographical error, my lord. I cannot shy away from that fact. But kindly seize, my lord, I am defendant number 1 and the constituent attorney number 2. So it was in effect, my lord, by both the defendants. Then, my lord, kindly takes the trouble, takes the next page, my lord, page 38. Sees the counterclaim.
38.
Sees page 38, the counterclaim. Well, counterclaim also bears both names of both the defendants, my lord. So, my lord, what the problem was, I'll be very frank and candid. The problem was, my lord, in the written statement, I had said defendant. That should have been defendants. So, my lord, what I would be beseeching, my lord, to do for the timing, subject to what eventually falls from my lord.
My lord, may I tell one thing, my lord? My lord, that, my lord, the cloud can be dispersed.
Yes.
If your lordship kindly have a look, my lord, page number 37.
Yes.
Page number 37. That is, my lord, the affidavit portion of the, my lord, the written statement.
Yes.
Now, my lord, kindly have a look. Affidavit affirmed in this way. I, Mahesh Chaudhary, the defendant number 1. My lord, he says, I am the defendant number 1. It is not stopped here. And constituted attorney of defendant number 2.
Yes, my lord, precisely.
Conversion. How can it can be done? When already against the defendant number 2 matter was appearing for ex parte hearing, then whether, my lord, by way of this, whether that can be removed.
So when was
He
this?
says that I am the constituted attorney, and that is why the court rejected it. Court said, my learned friend says that it was filed on behalf of 1 and 2 both. We are not against that. Yes, that is the fact. But the fact also remains that when you file on behalf of defendant number 2, the court rightly observed and said that you cannot do this. Because against the defendant number 2, it was appearing for ex parte, and unless that is removed by taking steps correctly, and the court has to satisfied on that, how can you do that? That is exactly the question, and the court rightly pointed out.
In fact, my lord,
my lord filed a revision petition instead of doing the right thing at the right time. Filed revision petition, and my lord obtained an injunction.
So far this
everything.
So far this defendant number 1 is concerned, written statement was filed long back.
Yes, that also, my lord, it has been recorded in the order sheet.
So
Kindly have a look.
It says for acceptance of counterclaim. It does not say acceptance of written statement.
Kindly have a look. My list of dates. Very short list of dates.
Looks into the order dated 21st of January. It says acceptance of counterclaim, not written statement.
On 31st of January 2016.
Yes, I say so.
And 31st of January.
So 31, the written statement was filed
Yes,
by defendant number 1, along with counterclaim.
Yes, yes, and now kind.
Oh, this is all with regard to defendant number 1.
Yes, now kindly sees for fixed sir for acceptance of counterclaim. So, my lord, so the written statement, so far as defendant number 1 was concerned, was accepted. I was not on that. My lord, what I am saying is, my lord, what the learned judge in the court below asks me to do on 26th of March 2019 is this, my lord, acceptance. What my learned friend says is I must go back and file an application.
Everything recorded in order number 5.
My lord, I accept the fact.
Number 5 annexed to this.
I accept the fact, my lord, that I need to go back and file an application. But what I am aggrieved, my lord, what I am aggrieved by is the rejection part of it. He has rejected, my lord, kindly sees the order. He is rejected by written statement and counterclaim. That's the problem.
Rejected the written statement and counterclaim. So far, defendant number 2 is concerned.
Kindly seize the order, my lord, 10th of July 2019.
10th of July.
Yes, last order, my lord.
You see, so far defendant number 1 is concerned, written statement is already accepted long time back.
Yes, that is what I am.
So far 1 is concerned, there is no
That is-
scope to reject.
I
If
bow
it is
down.
okay, so far number 2 is concerned, you see,
Till
suit
the
is
expert
so
is removed.
the court is very clear. The suit is on ex parte board against defendant number 2.
Yes.
Therefore, defendant number 2 cannot join with defendant number 1. Yes.
Just a minute. May I
Yes.
draw your lordship's kind attention, my lord, to my lord, the order number 26th of March 2019. Just, my lord, at the, my lord, the middle portion. It, my lord, the sentence, my lord, starts.
23.
It appears. It appears. That's this paragraph.
26th of March 2000.
26th of March order. 26th of March order. Have you lordship got it, my lord?
26th.
Yes.
26th of March 2016.
No. 26th of March 2019. One of the impugn order. 2 orders they have.
Yes.
26th of March 2019, my lord. Just lordship, kindly, my lord. Almost, my lord, not exactly bottom, but to some extent middle portion, my lord. The sentence start. It appears. Have you lordship got it, my lord?
Yes.
It appears that the defendant has appeared on 30th June 2015. He has filed his WS along with counterclaim on 21st of January 2016. Defendant has also filed court fees in respect of counterclaim. It appears up to this court that the WS of defendant number 1 has not been accepted.
This is what I'm aggrieved by, my lord. This is what I'm aggrieved by.
From the said WS with counterclaim that the same has been filed by defendant number 1 himself for himself and also constituted attorney for the defendant number 2. But the suit is proceeding ex parte against defendant number 2 since 30th June 15. No step has been taken by defendant number proceeding aside this ex parte order accepting one petition dated of 2019 for acceptance of said WS with counterclaim for his delayed filing. Case record suggests such and such. Then, my lord, in the aforesaid circumstances, acceptance of WS filed by defendant is kept pending, and defendant is giving liberty to take their steps.
This is, my lord, what I'm aggrieved by. How can he keep?
Actually, you see, defendant number 1 cannot be penalized because he took the steps in the right time.
Very good.
There may be some defect.
I accept this.
Defendant number 1 cannot be penalized.
I accept this, but
Now, who is both the defendants are before this court?
Yes. My lord, that is the reason. My lord, that is the reason I said this, my lord.
My lord, may I tell one thing? Steps are to be taken immediately, my lord, as per if your lordship so direct, my lord, then, my lord, within a specific period, steps be taken for removal of that expression of that, my lord, or the order, my lord, regarding the matter be taken as ex parte against defendant number 2. Let them take step. That application be heard, my lord, within a specific period. And, my lord, with regard to the counterclaim, my lord, we have filed an objection petition. That is also pending. That with regard to the maintainability of the counterclaim, my lord knows that counterclaim very good they can file at any stage, but before trial.
See, so far written statement is concerned, courts can take a liberal view. But
Yes,
so far counterclaim is concerned, that provision has to be complied
If my
with.
counterclaim is not
And
maintainable,
another thing,
I'll file a suit somewhere else. It's as simple as this.
because there are limitation point and jurisdiction point also.
My lord,
The
that would be,
pecuniary
my lord, that would be in the nature of a
Let-
demurrer application. Under orders, that would be in the nature of a demurrer application under Order 7 Rule 11.
Anyway, anything else you want to submit?
But my only issue, my lord, as I suggest, subject to what eventually falls from, my lord.
That is to be taken.
My lord, the steps we take
Moral application.
keeps this in 2 weeks' time. Let me take the steps and come back. I'll indicate to the court that the steps have been taken.
I am not opposing to that.
No,
If
kindly.
any other day again matter is taken
No,
up,
no.
my lord,
Or in the alternative, but I'll give an alternate
I have
solution as
no
well.
objection. But the thing is, the order can be passed right now also.
Passes the order.
I leave it to your lordship.
Either I can dispose it and grant liberty or keep pending and grant liberty.
Yes,
What I say,
leave
my
it
lord,
to your lordship. Because after all, my
that I
lord,
leave it to your lordship.
I
I leave it to your
beseech
lordship.
your lordship to pass an order either today or, my lord,
My lord,
some other
that
day
I guess we leave
after
it to your lordship.
5 or 10 days, that the matter can, lordship, kindly dispose of this. So that matter can be taken up today. Since 2015, the matter is pending, and because of stay order passed in 2019, the matter is pending.
But
Yes, take down.
I can't stand in the way, my lord. I leave it to your lordship, my lord.
Learned advocates for the parties are present. Hard learned advocates for the parties. This application under Article 227 of the Constitution is directed against the order dated 26/3/2019 and order dated 10/7/2019 passed by Learned Civil Judge Junior Division, First Court, Barashat.
My lord, may I take my lord's leave?
Yes, yes.
I'm so grateful.
In TS number 121 of 2015. The grievance of the petitioners, defendants in the said cases that the learned trial judge, without applying the minds, have rejected the application for acceptance of written statement. It is the further contention that in order dated 26/3/2019, the learned trial judge refused to accept the written statement filed by defendant number 1. Mr. Sen, learned counsel for the plaintiff opposite party, submits that the petitioner's defendants are required to take necessary steps before the learned trial court in terms of order dated 10/7/2019, and prior to taking necessary steps, this application cannot be considered. Upon hearing the learned counsels and considering the materials on record, it appears that pursuant to the institution of the suit by the plaintiff opposite party, the case on June 2015 was directed to appear for ex parte hearing with regard to defendant number 2. Yes, defendant number 2 is petitioner number 2. Yes. Defendant number stroke petitioner number 2. Stop. 2 stroke petitioner number 2. However, with regard to defendant number 1 stroke petitioner number 1, date was fixed for filing written statement being 2/9/2015. On 2/9/2015, the learned trial court extended the time to file written statement on 21/1/2016. Stop. On 21/1/2016, the defendant number 1 filed written statement along with the counterclaim.
The defendant number 1
One.
claimed that that was, my lord, jointly with the
Yes.
That is the, my lord, the problem.
Thereafter, by order dated 26/3/2019, the learned trial judge was pleased to refuse the written statement filed. Now, was pleased to keep the written statement filed by the defendant number 1 in abeyance and granted the said defendant necessary steps in this regard. Stop. The observation made by the learned trial judge is as follows. It appears that page নেই trial court order folded page করে দিচ্ছি। Upon perusing the record, it also appears that the defendant number 1, at the time of filing written statement, has incorporated that the written statement is also filed on behalf of the behalf of the defendant number 2. Stop. As the case was running ex parte with regard to defendant number 2, the defendant number 2 cannot, without the leave of the court, file said written statement by getting the order recalled from the ex parte board. board. Thus, on 10/7/2019, learned trial judge was pleased to observe that the suit is on ex parte board against defendant number 2. Therefore, the defendant number 2 cannot join with defendant number 1 in filing written statement with counterclaim without setting aside the ex parte order. In the facts and circumstances, this court is of the view that as the defendant number 1 filed the written statement within time, the said defendant cannot be penalized due to some technical defect. Stop. Thus, however, with regard to defendant number 2, as the defendant number 2 did not file the written statement within the period fixed by the learned trial court and the case was running ex parte board, the said defendant cannot file the written statement without getting the order fixing the case on ex parte board being recalled. Stop. Thus, in the interest of justice, this application under Article 227 stands disposed. The defendant number 1, petitioner number 1, as well as defendant number 2, stroke petitioner number 2, is granted liberty to file necessary application for removing the defect before the learned trial court. Stop. Such petition shall be filed on the next date fixed before the learned trial court. In the event necessary applications are filed by the defendant number 1 and defendant number 2, the petitioners herein, the learned trial court shall consider and decide the same in accordance with law without being influenced by this order.
Certain specific period. Within 2 months, within 3 months.
In the event the necessary application is filed for removing the defect and to file the counter statement and written statement by the defendants, learned trial court shall decide the same in accordance with law within a reasonable period, preferably within 4 weeks from the next date fixed, without being influenced by any of the observation made by this court.
And my lord,
it is hereby made clear that I have not gone into the merits of the case, and all points will be kept open to be agitated before the learned trial court.
And my lord, the maintainability of the counterclaim immediately after that can be taken up.
I have said all points are kept open. I have not gone into the merits.
And my lord, if
yes,
if that
yes is disposed.
If that application is not filed within that date, then my lord kindly consider that otherwise then order shall remain. If that application is not made within such a period, then my lord what will happen? Then
No, when is the next date fixed?
The next date.
No, my lord. I've said that you have to file the application on the next date fixed.
Yes, my lord, after 4 weeks, my lord, next date.
No, when is the next date? I've directed you to file.
Both of us can my lord make an application to prepone the same. If your lordship
I have not said it. It's better, otherwise it will cause inconvenience to the trial court. File it on the next date fixed.
Then my lord,
just one line.
I think not before, my lord, the middle of August, because 6th or 7th July was the date. Then my lord, that was adjourned. So I think at least in between 1 month must be there. So not before 7th or 8th August, that I can tell before your lordship. Because at the first week of July, the last date, and that was adjourned. So
you want a penal clause that if it is not filed.
Otherwise, my lord, kindly, my
lord. It is hereby made clear that in the event the said applications is not made on the next date fixed, the learned trial court will have the discretion to give some extension, but that cannot be more than 7 days. That can be extended by the trial court maximum up to 7 days.
And my lord, even even my lord, the failure of that to take that opportunity, then my lord,
No. I've made it clear that
the court shall my lord, the court shall go on, my lord, proceeding the matter, because otherwise, lordship, matter cannot be, my lord, they can take
আচ্ছা ওখানে লিখে seven days তো
to come again.
learned trial court shall have the discretion to extend the period to the maximum about 7 days. ঠিক আছে? Failing which the defendant's petitioner will have no further opportunity to make application.
15 days, my lord, 7 days.
No, I have said that if you are, on the by the next date, okay, if you are unable to file, the trial court will be empowered to extend the time maximum 7 days.
My lord, Advocate Jayanto Samanta is appearing for the petitioner. One matter is running on in court number 16.
Yes, Mr. Ali, what is the?
This is, Lordship, application challenging the dismissal of Order 7, Rule 11. It is my suit. The ground is that.
Oh, their petition, their application.
Their application.
Anyway, let it be not today.
Very well, Mal.
Grateful.
Yes. But it will be called on.
31, Lordship. 31 কি আছে? Lordship, this is dismissed for default. Now, Lordship, kindly come to the impugned order.
I am for the opposite party.
19 December.
You are for the?
I am for the plaintiff petitioner.
You are for all the opposite parties.
Lordship, suit for declaration, permanent injunction. Lordship,
Okay, dismissal. When was the matter dismissed?
Also, the dismiss for default for non-compliance of the court's order.
Yes, let us see the order.
Order number 26, 19 December 2019. 35. Yeah, the order is the last.
Yes, 24/6/2024, the matter was dismissed.
No, Lordship, this revisional application dismissed, subsequently restored. Lordship, I have challenged the order of the learned court below, that is 19 December 2019.
So question is, now the revisional application is on its file.
Yes.
So what is the order under challenge?
So kindly come to the order number 26.
Okay, let me see.
So this is certified copy, so there is no pagination. Second page of the certified copy. সেটা সাইড করে দাও, এখানে চলে যাও।
সেটা সেট করব। এটাকে সেটা সেট করব।
Yes, today was fixed for evidence of DW1.
Yes.
You are the plaintiff petitioner.
Adjournment.
You are the plaintiff petitioner.
I'm plaintiff petitioner. Defendant files Hajira. No one is present to move the adjournment petition. Lordship, there was a ground, Lordship, why the learned advocate could not appear. Lordship, I have stated in paragraph 6 of the revision. Now, it appears from the record that an order sheet that the evidence of the plaintiff has been closed on 21st, order number 21st, dated 15 July 2019, due to the laches on the part of the plaintiff. Lordship, plaintiff's evidence could not be, Lordship, the closed properly. Plaintiffs could not able to, Lordship, the give evidence. Now, today plaintiff has spread for time adducing evidence of PW1. It appears plaintiff has not proved their case by adducing evidence. Thus, no question arises to disprove the contention of the plaintiff by adducing evidence of the defendants. Thus, under such no question arise for evidence of DW, as there is nothing to decide in the instant case by passing an adjournment over the same by hearing argument. So it is required to dismiss the default for non-compliance of the court's order. Adjournment petition is therefore rejected. Hence, the instant suit is dismissed for default for
So,
non-compliance.
plaintiff prays for adjournment, defendant files hearing. So, it was fixed for DW1.
Earlier it was fixed for my lord PW1.
Yes, PW1 could not be completed properly.
Order number 21. This is my lord the order number 21. They have got annexed, my lord. Kindly see.
Now, Lordship, first of all, Lordship, this type of order, Lordship, this is not a revisional order.
Order 9 rule
Revisional order, Lordship, order 9 rule 9. Yes, order 9 rule 9 is the procedure to recall this order.
before the learned court bill. Kindly see, my lord, the order number 21. What they have done. My lord, may I read? Today is fixed for PH as last chance. My lord, plaintiff files adjournment.
Lordship, I am not on merit. Lordship, this is required to file order 9 rule 9.
Oh, no, you are for the petitioner plaintiff.
Plaintiff petitioner.
So here you see, you are for the petitioner plaintiff. The suit was dismissed for default. So against that you have come.
Yes.
That was come.
This revisional application, my lord, is not maintainable. Your lordship may kindly see, my lord, the provision of order 9 rule 9. My lord, may
Oh, here you see, here the case is your adjournment petition was rejected. It is, if suppose you are absent and the matter is dismissed for default, then the proper remedy is recalling. But here you are present, you sought for adjournment.
but at the time of call, none appears.
So, no, none moved the adjournment petition.
None was present.
None was present. Deliberateness by the plaintiff that they have failed to, my lord, adducing their PW1. My lord, their evidence, my lord, on repeated occasion. Kindly see, my lord, the order number 21. What is the finding of the learned court bill? Order number 21, my lord, dated 15th July 2019. May I read, my lord?
Also, kindly come paragraph 6 of my petition. There was a reason for that, why the petitioner could
Yes.
appear.
Now, what do you intend to do? You want to withdraw and file?
So, order 9 rule 9, liberty to file.
No, my lord,
order
there is no liberty. My lord.
Obviously,
No,
otherwise,
my lord,
this
let
is-
it be, my lord. Kindly, my lord, leave it to the discretion of the learned court
No.
below. If your lordship
Since
may grant the
2019,
liberty, my
this
lord,
revisional
but they
application
have
is
to
pending.
file this, my lord, limitation application to the learned court below. If your lordship may, my lord, kindly grant them the liberty, my lord, there is no question of, my lord, this.
Paragraph 6, what have you stated?
Paragraph 6 that my son expired.
Annex death certificate annex.
Death certificate I have annexed.
No, paragraph 6
6
of your application.
No, paragraph 6.
7.
7. Kindly come paragraph 7. Lordship, my right cannot be closed.
I am not
What's
saying
the
that, my lord.
Yes, record an order.
cannot be closed. Lordship,
saying
this, since 2019, this matter is pending. Lordship, also liberty to consider
Learned
application for
advocates for the parties are present, hard learned advocates.
Liberty, my lord.
This application under Article 27 of the, please,
I'm
Article
entitled to get
227 of the Constitution
27 years.
against the judgment and against the order dated 19/12/2019 passed by learned Civil Judge Junior Division, Second Additional Court Contai in TS 295 of 2018. Stop.
19 থেকে pending.
By order dated 19/12/2019, the learned trial court was pleased to dismiss the suit for default, although the petition for adjournment was filed. Stop. The observation of the learned trial judge is as follows. You can folded page. It is the contention of the petitioner that the son of the petitioner died on 4/8/2010, and on the death of the petitioner's son, the petitioner was not mentally and physically fit to look into the case, and there was irregularity in such appointment. Stop. Learned advocate for the respondent opposite party submits that the case filed by the petitioner is not maintainable. Upon considering the order passed by the learned trial court on 19/12/2019, although the petitioner in this revisional application has furnished a cause for being absent on the date fixed, but such application ought to have been made before the learned trial court. Stop. In the facts and circumstances, there is no scope for this court to pass any orders under Article 227 of the Constitution. Stop. Thus, this application stands disposed. Stop. It is hereby made clear that this court has not gone into the merits of the case and the application, and this order will not prevent the petitioner to file necessary application before the learned trial court for consideration and orders.
And also to consider my delay in filing the application because due to pendency.
Although a delay is caused, but such grounds for delay may be made before the learned trial court for necessary consideration.
Okay.
Lordship, before the fixed matter is taken up today, item number 37 of the list, Lordship, the interim order is due to expire today, Lordship. That the interim order.
Item 37.
That is dismissed.
Yes, disposed. I have not used the word dismissed. Learned advocates for the petitioner is present. No time today. The matter stands adjourned till 3/8/2026. The interim order granted earlier stands extended for a period of 4 weeks or till further orders, whichever is earlier.
My lord, I have.
For 5 weeks or till further orders, whichever is earlier.
My lord, I have a similar prayer in items 35 and 36, where interim order we mentioned, Lordship kept it on 13th of July, but business of the court did not permit the matter to be taken up. So if Lordship, the interim order can be extended and Lordship.
35 you are for?
I am for the petitioner, 35 and 36.
Okay, 35, 36 also same order.
My lords, if I may, I just wish to mention item 34. It's a very small matter. I'll just take.
I'll take it up next Monday. Yes, yes. No. Next Monday.
My lord, I am not the appellant in this case.
Yes.
My lord, initially in this case, case is filed under section 163 MB Act. Now the only contention is here, according to claim petition, 3,500 per month was the income. So it exceeds 50,000. Now I filed a CAN application. This is the copy of the CAN application.
So case was originally filed under 163A.
163. Subsequently, I filed a CAN under section 166 to convert the case 163 or 166. So at any stage it can be done. This is the decision of the Honorable Supreme Court. My lord also knew that at any stage it can be, even in appellate stage, Supreme Court says. So now the question is, this is the decision of the High Court, where this is case under section 163 and High Court says that whether the petition filed on 163 can be permitted to amend, to be amended to be one under section 140 160. Yes, claimant can certainly entitled to amend this, but not 163 as well at the same time 166. Both cannot be taken.
Yes, what is the paragraph? Which paragraph?
Paragraph first covering page, cause title, para 4-5 also. First para.
No, paragraph of the judgment, not that
4-5 para. Paragraph 5 last para is very much clear. Paragraph 5 last para 1. Page 834. Page 54. Amount of compensation fee less. Statute is in view of the matter, the claimant in an application under 163 of Motor Vehicle Act is certainly entitled to amend the claim under 140 and 163. The bar is only there can be simultaneous claim under section 140 and 163 or 163 or 166. This is the another decision of the High Court. I take to Devan. Where it is written that whether the claimant has filed a claim under 166 entitled to get claim application converted under 163 at any stage of proceeding. Yes, denying such right would defeat the very social object of granting speedy and expedient compensation to the victim of accident. I take to Devan. ঠিক আছে, ঠিক ওটা দিয়েছি, দেখেছি স্যার দিয়েছি, পেন কি বলছিস? হ্যাঁ দিয়েছি স্যারকে দিয়েছি। This is the decision of the Honorable Calcutta High Court. Where is also same case.
Here you see in Calcutta High Court, the claimants were permitted to initiate proceedings under 166, provided the compensation amount is returned.
Only 12,000 was awarded, 12,900. So my lord can deduct it. After deducting the case may be proceed.
Because you have collected that amount also. So
only
not that it
12,000.
is deposited. You have already collected that amount.
Only 12,000. The amount was first 12,900 only. So my lord can order the pass.
No, this is the observation of the
deducting
division bench.
Deducting this amount.
Yes, proceedings can be initiated provided the claimant return the entire amount.
12,500 and 900 has already been received. So deducting that, my lord, pass the order. And it can be made at any stage of proceeding. That is the, my lord knew it. This is the decision of the Supreme Court, but it can be made at any stage of proceeding. Even in appellate state, Supreme Court. I have underlined the জানাই তুমি ধরবে দিয়েছি would be whether the amendment to the claim petition could be granted at appellate stage, yes. appellate stage করা যাবে না, সুপ্রিম কোর্টে বিবেচনা করতে পারছে, বুঝেছ? আর এটাও তো অ্যাপিলেট কোর্ট। দেখা যাক না সাহেব কি করে। যেটা ধরেছিল সেটা উত্তর দিয়েছি আমি তো জানি ওটা ধরবে। ঠিক আছে।
Yes, have you shown your judgments to your learned friend?
No.
You are relying upon?
I am giving. No, Calcutta High Court is no. I have given the Xerox copy of the earlier date. My lord had heard the matter. My lord kindly see page 14 of the paper book, where my lord the tribunal বিশেষ লেখা নেই কেন ये कागज দিয়ে দেনা
তিনটে দিয়েছো ওখানে হলো চারটে আবার এখানে লিখতে নয় তো ওইখানে চারটে আছে তাই জিজ্ঞেস করছি একটা জাজমেন্ট দুবার দিয়েছে
সুপ্রিম কোর্ট একটা কেন্দ্রের একটা আছে
তা দিল্লি है
স্যার ওটা একটা
Really নেই
সত্যি কথাটা বলো দেওয়া জাজমেন্ট নেই সেটা ঠিক আছে প্লিজ কাম প্লিজ ট্রুথফুল
Yes, under 163, the scope is very limited.
Yes.
For those injuries.
If the my lord allow me to grant the petition, petition, then it may be done to 166. Then scope is not limited. My lord, kindly see page 14 of the paper book. That's why I filed the can.
Yes.
My lord, paper book para second para, page 14, my lord.
Yes.
Be that as it may, the documentary evidence supports the contention of the petitioner that there was a road traffic accident and the petitioner sustained injury. This is the admitted fact. Now the question is regarding medical expenses, my lord. Before that, my lord, regarding disablement, my lord, the permanent disability, my lord, page 15. As regards the permanent disability, petitioner has one with a certificate given by one orthopedic surgeon who has opined about the permanent disability. Curiously enough, the doctor did not treat the petitioner victim and the certificate was given after about 3 years from the date of accident of treatment. This certificate is usually given by a board having panel of doctors, including the sociologist of any, etc., etc. So I disbelieve the disability certificate as it was not there is not doctor who did not treat the patient. Before that, my lord, I have produced several decisions regarding the disability certificate. The doctor can issue the certificate. Now, my lord, kindly see the page. Page 47, my lord. The doctor who issued the certificate, my lord, page 47. He is the MBBS, MS, FRCS and MS orthopedic surgeon, the head of the Department of Orthopedic Surgery, Calcutta National Medical College and Hospital.
Did he treat the patient?
No. He only issued the certificate. Now that injury regarding...
May I submit one thing, my lord? Your lordship will kindly permit me. My lord, I need to file an affidavit. Lordship kindly grant me 6 weeks time.
Okay. Record an order.
Okay.
The learned advocate for the respondent insurance company prays time to file affidavit in opposition to the application for conversion of the case. Let the affidavit in opposition be filed on or before 24/8.
My lord,
Lord, at least 6 weeks.
This is a case of
1 month, 4 weeks you are getting.
But I'll try.
This is a case of 2005, my lord.
It is the case of 2005. I'm thankful to him. And in 2026, he is coming before the court after taking clue from the court that yes, to file an application for amending the case.
All right, you
after 21 years. And he is worried about 4 weeks and 6 weeks.
Okay, 24/8.
24/8.
To file
But
affidavit
it
in
may not be
opposition.
earlier.
Reply, if any, by 14/9. Affidavit in reply.
14/8.
24/8 is opposition, okay. Reply by you, if any, by 14/9. Let this matter appear on 15/9/2026.
Milord, I hope in the meantime he gives me the reference of the judgment what he has placed before your
Yes,
lordship.
yes, yes. Give them a copy.
I have handed over 3 copies, 1 copy I have.
That's what I am saying. Please give me, or please give the reference at least.
ঠিক আছে, reference দিচ্ছি। এটি judgment গুলো একটু দেখি আমি।
Grateful to your lordship.
রুক্মিণী দেবী, রানী দেবী।
So 38 was divisional application.
কখনকার দাদা?
নিউ ইন্ডিয়া।
Yes.
কখনকার 2009 কোথাকা দিল্লি।
Item 38.
নিউ দিল্লি।
No, 38 is a hearing matter. So some other day it will be fixed next Monday.
এক সেকেন্ড স্যার, বলছি যে লাস্টে যদি নেন, কারণ এটা ফাইনাল জাজমেন্ট বেরিয়ে গেছে এবং ফার্স্ট অ্যাপিলটাও ফাইল হয়ে গেছে, জাস্টিস ডিভিশন
Next Monday তে নেব।
10 মিনিট লাগবে স্যার।
Next Monday তে নিয়ে নেব আর কি। You are appearing in this matter? Okay. So have you so next Monday I shall take it up. Hey, next Monday it will appear as a fixed matter.
Mr. Singh is the appellant. I prefer on cross objection.
Yeah, paper দিয়েছো? Milord, this is insurance appeal, Milord.
এই যে
Milord, it's a case of death, Milord. An accident of 2021.
Yes.
Milord, as I said, Milord, it's a death case, an accident of 2021. Milord, the victim, Milord, was a alleged mason, as it happens, Milord. The one who doesn't do anything becomes a mason before your lordship. Milord, the principal sum, I'm sorry, Milord.
Yes.
Milord, the principal sum of rupees 8,86,000 was awarded, Milord, in favor of the claimants. Insurance company has secured the said amount with interest before my lord's court. Milord, I have mainly come, Milord, on the point of non-involvement of the offending vehicle, Milord, which is alleged to be involved in this particular case. Learned Tribunal Judge, Milord, has considered the monthly income of the victim at rupees 6,000. Milord, I am also praying before your lordship, Milord, since Milord, proper evidence was not there with regard to the income, and my lord will be kindly considering, Milord, with regard to reduction of the income. Milord, firstly, on the point of non-involvement. Milord, it was alleged
Yes.
Milord, it was alleged that, Milord, that the victim was hit by a vehicle.
No, it was named in the FIR, vehicle number.
No.
It was unknown vehicle.
Yes.
Unknown, not
Alleged offending vehicle was not involved in the accident. Rather, another vehicle number was involved.
No, no. Vehicle number, yes.
Yes, unknown vehicle.
Unknown vehicle.
Milord, FIR, Milord, is at page number 21.
No, FIR.
No, FIR, that is the evidence, Milord, page 44.
Page 44, 46 is the, my lord, complaint. Ache number.
Complaint ache. WB 33 194. Milord, in the written complaint, the number was mentioned.
Page
Milord,
21.
Milord, page 46, my lord will kindly come to. Page 46, Milord.
Yes. It was unknown vehicle.
No, no, the number was given.
Number
The number was given, Milord. WB 33E 1949, that is at page number, Milord, 46. Your lordship will kindly see the written complaint.
Yes.
In the middle of it. Milord, in the written complaint, it was there. But, Milord, why I say, Milord, this vehicle was not involved? It is because of, Milord, the evidence of OPW1.
That is page?
Page 21. Your lordship will kindly take a note, Milord, the offending vehicle which was alleged to be involved. Your lordship will kindly write down its number, Milord. It was WB 33 capital E.
Okay, WB
33 capital E / 1949. Milord, this is the offending. It's a Tata.
As per
Ace.
FIR.
As per FIR, Milord. As per FIR, charge sheet, and eyewitness. Milord, why I say this vehicle was not involved? Milord, I have invited my lord, Milord, to page number 21.
Yes.
Milord, page number 21, Milord, is the evidence of the person who was the driver of this vehicle. Alleged driver. Milord, he was charge sheeted.
Yes.
Milord, my lord has written down the number, that is 1949.
Yes.
My lordship will kindly read, Milord, page 21 with me, Milord, if I can read it before your lordship. Previously, Milord, this is the driver.
Yes.
OPW1. Previously, I have a vehicle bearing registration number WB 33 5748.
Yes.
This vehicle met an accident at Chotur Bazar More, PS Narayangore. At that time, I was driving the said vehicle. Milord, he says he was the driver come owner of this vehicle number 48. This vehicle met with the accident. Vehicle 48 met with the accident.
5748.
While investigator of the insurance company interrogated me at that time, I told him that actually the vehicle bearing registration number 48 met with the accident at Chotur Bazar under so-and-so. But the lordship will kindly note this. But since there was no valid insurance policy in respect of vehicle number 48, another vehicle number 1949, Milord, what my lord has written, 1949 was planted to initiate the proceeding. This is by the driver before the court. He admits the lordship will kindly come to the cross-examination. I had no enmity with the Narayangarh police station. It is true that it is a market in front of Narayangarh police station. There is another market at the distance of so and so. It is true that the accident took place at Narayangarh, which is situated in front of so and so. It is true that after the accident, I fled away with the vehicle. It is true local people chased me and caught me. Police seized vehicle as well as my driving license. Police arrested and forwarded me before the learned ACGM Kharagpur. I cannot recollect the date when the investigator of the insurance company interrogated me. Local people assaulted me. At the time of accident, my driving license was valid. I have no papers to show that the vehicle number 48 met with an accident on the relevant day. Milord, the vehicle which he owned and which he says that he was driving. Then your lordship is the important line. It is not a fact that I caused the accident by driving the vehicle number 1949 and thereby caused the death of the victim. Milord, in cross-examination, he again denies specifically. Milord, in chief, he says that 49 was not involved. It has been subsequently planted because the original vehicle 48, which he owned himself and he was driving, did not have the insurance coverage. And in cross, he's very specific and very categorically in denying that vehicle 49 was involved. No criminal case was initiated against the vehicle number 48 because that was, my lord, removed from the scenario. And this
No, FIR is 1940. FIR is 1949.
my lord, everything is correct. On paper, my lord, 1949 is everywhere. But my lord, the driver comes up and says that no, 1949, I was not driving. I was driving 48. I was the owner of 48 and it did not have the insurance coverage. That is why 49 was planted. In cross also, my lord, he substantiates that. It is not a fact that I have deposed falsely as per the instruction of insurer. It is not a fact that no accident was caused by the vehicle number 48. Thrice, my lord, he emphasizes that vehicle number 48, which was owned by him, which was driven by him, and which did not have the insurance coverage, was the vehicle which was involved in the accident. And he says that 49 was subsequently planted. And my lord, once it is planted, then my lord, everything becomes smooth. My lord, the eyewitness is there, Caesar is there, charge sheet is there. But the owner of the vehicle, my lord, says the driver who was charge sheeted, he says that this vehicle was not in.
Which vehicle was seized?
49?
No, vehicle seized was 1949.
Yes. And my lord, once after my lord written complaint, everything falls in line. Because my lord, this vehicle 48 was not having the insurance coverage, which is an admitted fact by its owner. Once it is found, so that vehicle was removed from the my lord picture and 49 was brought in.
After how many days FIR was lodged?
My lord, same day.
Same day.
Yes.
Same day.
My lord, this is what, my lord, the sum and substance of, my lord, my cases. Now, if
So Caesar and everything all 1949.
Caesar and everything all 1949 because, my lord, written complaint was 1949. That seems to be, my lord, after removal of 48 from the scene. The moment it was found, my lord, when vehicle 48 met with the accident, it was found it doesn't have the insurance coverage. It was removed. 49 was brought in with the same person as the driver, and the driver comes up before the court and says that yes, I was driving 48.
And he was the owner come driver.
Owner, my lord, that is written in the first page. Previously, I have a vehicle bearing number so and so and so. In the evidence, it is there. And he says he did not have the insurance coverage. That is why it was removed from the scene.
So for his driving, that is confirmed.
That is confirmed. My lord, insurance company, my lord, fortifies this evidence at page number 22. An officer of the, my lord, the insurance company comes up.
Yes.
Page 22, my lord. My lord, it says that this vehicle 49 was not involved in the accident. My lord, page 22, paragraph
page 24.
My lord, page 20, it starts from 22, my lord,
Yes,
the chief.
22, yes.
My lord, this is the officer of the insurer. Page 22, my lord, paragraph 3, that during investigation of the company, it is disclosed that the alleged offending vehicle 49 was not involved in the accident, and the accident was caused by the vehicle number 48, as per the statement of charge-sheeted driver. My lord, then 23, paragraph 5, that is the vehicle number 49 was not involved, and the same has already been admitted by the driver of the alleged vehicle, that is a charge-sheeted driver, in his examination before the chief. So this opposite party has no liability. And then in cross-examination also, my lord, in examination in chief at page 24, it continues. Third para, during investigation by our company, it is disclosed that the offending vehicle was 48 and not 49. And the driver of vehicle number 48, Jitin Dulai, accordingly, 49 was not involved, and our company is not liable to pay any compensation. My lord, on relying upon these documents, my lord, and this testimony, which has withstood, my lord, the rigor of cross, I say, my lord, this 49 was not involved in the accident. The alleged driver, the charge-sheeted driver, who comes up before the court, who stands in the witness box and says that, no, this vehicle was not involved. Rather, I owned a vehicle that was involved. And since that vehicle did not have the insurance coverage, this subsequent vehicle has been planted in the case. My officer also goes there. And my lord, he submits before the court that since this vehicle 49 was not involved, we are not liable to pay insurance indemnification. Lord, this was one part. Lord, the second part was with regard to the quantum. Lord, the award, Lord, passed by the learned tribunal starts at page 26. At page 32, Lord.
So witness is the complainant. The complainant is the FIR. The FIR maker is PW2. In
No.
this case,
No, my Lord, no.
who said this 1949? The
Lord,
FIR maker is
no, the FIR maker is not the witness before my Lord's court. Before the court of the tribunal, my Lord. He's an independent person. That is not at page number 18. The eyewitness, my Lord, is asking. Lord, the page number 18 is the evidence of eyewitness. If my Lordship kindly comes to
18.
My Lord, 18.
Yes.
Is my Lord there, my Lord?
Yes.
I, Sheikh Rajesh, so and so. That on paragraph 1 or paragraph 2, paragraph 1, on 15th August at about 6:30 p.m., I was standing at this bazaar. At that time, deceased Sheikh Halim was coming by work from this place to this place. When he reached near Narayangor Bazaar, at that time, one Tata Ace wearing number 1949 was coming from backside with high speed, rash and negligent manner, and dashed the victim from behind. This is what he says. And not in cross-examination, if your Lordship kindly comes to page number 20 of this eyewitness.
Yes.
How, my Lord, he is an interested eyewitness. The cross-examination, my Lord, at page 20, is my Lord there, my Lord?
Yes.
The first sentence, Sheikh Halim deceased was my childhood friend. And what he does, I never told the relatives of Sheikh Halim about the incident. Your Lordship will see, my Lord, this. How much to believe on this? Childhood friend. In the court, he says, I saw him, that my childhood friend met with an accident. Maybe he was dead, and I did not inform his family. First time I am telling the fact of accident before the court. No police, no family, no hospital. I have not received any summons from the court to depose in this case. Petitioner number 1 requested me to depose in this case. No, my Lordships, this is the entire testimony. I knew the victim, he was my childhood friend, and still I did not inform his family members that he met with an accident. And the accident which caused death. Is it believable? My Lord, I put this question to myself. And this is the sole eyewitness testimony. Against that, my Lord, it's an interested eyewitness. Against that, the independent witness, the driver, who has got nothing to do with the accident, my Lord, comes up before the court, who is allegedly, my Lord, has caused the accident. He says that this vehicle was not involved. The other vehicle was involved, which was not insured. 1:1. An interested witness who is tutored, whose testimony cannot be believed, versus the person who had driven the vehicle, who is charge-sheeted driver.
Yes.
This is 1:1. And you had got no interest in this.
Driver come owner.
Charge-sheeted driver come owner of the previous vehicle, which was not insured.
Previous vehicle, as per the witness, it is not insured.
As per the said owner driver, it was not insured with the vehicle number 48, which was actually involved as per his evidence. And then he says 49 was planted. The owner of 49 is somebody else.
Okay. 1949 is planted.
Yes, that's what, my Lord, the charge-sheeted driver who committed the accident comes up before the court and says.
Yes.
And, my Lord, I have shown, my Lord, the evidence.
How many witnesses are there? Police has examined.
My Lord, there are, my Lord, as far as in the tribunal, there are 2 witnesses.
No,
I have
police,
my Lord. The
charge sheet. How many witnesses?
10
Your Lordship will kindly come to the charge sheet.
Charge sheet, my Lord, page 50.
50.
Yes,
Mark.
50, particulars of witness 14, item 14. Patience, sir.
Thank you. This so-called eyewitness, my Lord, I use the term tutored eyewitness who came up before the court. His name is not here.
Yes, not required.
He is not a charge sheet.
So these are all witnesses, 4,
Yes.
5.
Yes. And
So complainant is not PW.
No,
no.
no. The complainant has not come before the court, and the person who comes up before the court, he is not mentioned in charge sheet.
So complainant is totally a third person.
Complainant is totally a third person.
Yes, next.
This was as far as the involvement part is concerned. There is nothing more to add to this. Now, the quantum, what I was submitting, in this case, learned tribunal judge, considered the monthly income of this mason, alleged mason, he was 22-year-old.
Aged?
22. At rupees 6,000. As I was showing to your lordship, the award starts at page 26, and I was inviting my lord to page number 32 of this award. The calculation part is shown there.
Yes.
In the middle, the computation.
Okay, no, personal deduction should be 50%. Unmarried?
No, he was married. He was
married person.
Married?
He was
Yes.
22 years.
Yes, one third deduction is there, that is.
Yes. Wife, minor, and mother. Parents. 4 persons.
This is your lordship is at the computation part,
Yes.
Rupees 72,000. That is 6,000 rupees per month into multiplier less 1/3, 8,16,000. Then this 70,000. The tribunal has not granted future prospect. I admit, whatever is there, the future prospect is to be added to this. This compensation would increase, if my lord even keeps it at this rupees 6,000, because future prospect, that would be 40%. Further addition would be there.
So future prospect is not added.
It is not added.
So even if 6,000 is kept,
it will go around 11-12 lakhs.
I have preferred for cross objection.
for not granting future prospect.
And income also, my lord. Accident took place in the year 2021. My lord, kindly see page 31. Page 31, bottom portion.
Okay, mason minimum wages is what? 6,000.
No, it would be 21 around 7,000 টাকার কাছাকাছি ছিল।
একটু বেশি হবে।
It was around 7,000. We do not have the
and
chart.
if he is not a mason, if he is
that is not true. That is what my submission before.
If it is some other labor or something.
Then it would be around 6,000. Anything between 6,000 to 7,000 it would be 2021. But mason has to be proved. That is what I
No, if he's an unskilled labor, then how much will be the minimum wages?
Unskilled labor.
Because mason is a skilled labor and his age is 22 years.
Yes, yes.
So you see, so young ages are not appointed as mason.
Lordship.
22, you expect 22 years boy will be a mason. He can be a laborer, supplier to the mason, assist the masons. That can be.
He can prepare made parapet also, my lord. If a person.
He can do everything provided you give an evidence.
Mason.
He can even fly an aeroplane. You give an evidence.
No, very difficult to believe that 22 per years person will be appointed as because mason is a skilled worker.
There is no documentary evidence with regard to the
No, that may not be, but
Lordship.
Considering the age, you see.
8,000 to 11,000, 852.
No, you are challenging. No, you are challenging the quantum of compensation. You are challenging the quantum as
I'm
the
saying
involvement.
instead of 6,000, your lordship will kindly make it 5,000.
Zone B করে দিয়েছে এটা দেখি।
No, even if I consider 5,000, then also I have to take future prospect.
Yes, that he is entitled to.
You give a calculation of provided he succeeds in establishing the involvement.
Lordship, I'll make a calculation with 6,000 with 40%.
5,000.
5,000 with 40%. Lordship. দাদা একটা
thought,
কাগজ
my lord, I am coming. Because,
Oh, you see,
my lord,
22 years age is
yes,
very
my lord,
difficult to believe.
it will not be 2021.
Maybe.
My lord, I am pressing, my lord, regarding.
একটা ইনভলভমেন্ট নিয়ে
My
এমনি
lord,
দুটো
page
নম্বরই আছে
31. My lord, kindly see page 31 regarding, my lord.
Lord, he was not supposed to get any money, my lord. He's getting, my lord, 10 lakhs, 12 lakhs.
My lord, kindly see 31 bottom portion. My lord, the observation of the tribunal in deciding, my lord, in calculating, my lord.
Anyway, yes, anything else with regard to main matter?
No,
You have completed.
No.
So you submit with regard to the main issue.
Yes, yes. At first, my lord, I have prepared, my lord,
Regarding involvement, you submit with regard to involvement.
at first, my lord, I am coming this poor part.
No. You have to defend Mr. Singh's allegation. If Mr. Singh succeeds in the first part, your case goes.
I shall fail. My lord, at first, my lord, kindly see their written statement. Starting from page 8. Page 8, my lord, first paragraph, that the application for compensation under section 163 MB Act is not maintainable in its present form and pair. My lord, this is a case under section 166.
166, yes.
Then, my lord, kindly see paragraph 11, page 9. That the opposite party submits that the opposite party is not aware at this stage as to whether vehicle bearing number such and such, my lord, that is the main, my lord, that vehicle is named in the FIR and is involved in the accident, or that the opposite party number 1 to be owner or the opposite party number 2 to be insurer of such vehicle. The claimants have not furnished detailed particulars of insurance policy and or relevant copy of insurance policy. This opposite party is highly prejudiced and demands for immediate production of the same, failing which the name of opposite party is expunged from this case. Kindly see thereafter, my lord, that the valid insurance policy registration document, fitness certificate and valid driving license should direct to produce in this case by the concerned owner of the alleged vehicle and or the claimant, failing which in it shall be presumed that there is a statutory violation of the condition of policy if all in force as contemplated in section 149(2) of the MB Act, and this opposite party is not liable to be indemnified the award amount of compensation as it all in near future. Thereafter, my lord, kindly see paragraph, page 10, paragraph 14. The same, my lord, statement has been that the claim applications are not admitted by OP, the nature, manner, and the cause of accident and the involvement of the vehicle and or the disease in the accident as stated in the column are totally denied. It is denied that on 15/8/2021 at about 6:30 p.m. while the deceased was proceedings by walking from Chotur Bazar to Narayangarh Bazar nearby Narayan PS by the extreme left side of the OT road to reach his house after end of work of mason, or when the deceased reached near Bazar nearby Narayangarh PS, or at that time one Tata S vehicle bearing number such and such was coming from backside with high speed or with rash and negligent manner, or suddenly dashed, or as a result deceased was thrown out on the OT road or sustained bleeding, grievous injuries, that fact, my lord, has been denied. And paragraph 15 also, your lordships will find that it is further denied that the accident took place due to rash and negligent driving of the driver of the offending vehicle bearing number such and such. The driver of the offending vehicle impugned denied involvement of any accident. Hence, this is a pure breach of trust. The claim is to be dismissed with cost.
So this is the denial of this
Only denial.
Driver, not insurance company. Insurance company may not have knowledge. The driver, from inquiry, the insurance company came to know that this vehicle is not involved. The driver of the offending vehicle Denied involvement.
Yes. Which vehicle has been involved?
No,
That's
no.
stated here. My lord, when inquiry has been made, certainly that has come into picture.
So that vehicle driver was
Before
that
delivery.
vehicle driver was examined.
Yes, I am coming, my lord. He will be treated as interested witness. As to why, my lord, that has been stated in the decisions of the Honorable Appellate Court. I shall place before your lordship. Here, my lord, kindly see, it is further denied that, again, my lord, 15, it is further denied that the accident took place due to rash and negligent driving of the driver of the offending vehicle bearing number such and such. The driver of the offending impugned vehicle denied involvement of any accident. Hence, this is a pure breach of trust. The claim is to be dismissed with cost. My lord, after that, my lord, before delivering of the judgment, written statement, the actual involved vehicle has come into picture. When that statement has been stated in the written statement, nowhere it has been stated. That is beyond pleading. Kindly see, my lord, the eyewitness. My cross-examination that has been, my lord, placed before your lordship. My lord, kindly see page 20. Again, I am submitting, my lord.
Yes.
Sheikh Halim, disease was my childhood friend. I never told the relatives of Sheikh Halim about the incident. First time I am telling the fact of the accident before the court. I have not received any summons from court to depose this case. Petitioner number 1 requested me to depose this case. It is not a fact that at the relevant time of accident, I was not standing at Narayangarh Bazar. It is not a fact that I have falsely stated that the offending vehicle did not dash the victim. It is not fact that I have deposed falsely. My lord, a person who is deposing before the court, whether his name is required to be incorporated in the charge sheet or not, that has been held by the Apex Court in Kusumlata's case. Your lordship knows that. A person who is deposing as eyewitness, it is mandatory, whether it is mandatory or not. My lord, kindly see. Paragraph 8 and 9. Paragraph 9 is the main. Paragraph 9. There is no reasons why the tribunal and the High Court would ignore the otherwise reliable evidence of Dhiraj Kumar. In fact, no cogent reasons has been assigned either by the tribunal or by High Court for discarding the evidence of Dhiraj Kumar. The so-called reasons that as the name of Dhiraj Kumar was not mentioned in the FIR, so it was not possible for Dhiraj Kumar to see the incident. It is not a proper assessment of the fact situation in this case. It is well known that in a case relating to motor accident claims, the claimants are not required to prove the case as it is required to be done in a criminal trial. The court must keep this distinction in mind. My name is not showing, is not incorporating in the charge sheet. That doesn't mean my evidence is to be discarded.
Court says reliable witness, not the tutor.
Yes.
Kindly see the evidence of OPW1. Cross-examination. From bottom, 1, 2, 3, 4, 5, 6. 6 line.
Yes.
I have no paper to show that the vehicle number WB33E 5748 met an accident at the relevant date. Though, my lord, he stated that I was previously owned the registration of the vehicle number 5748, but no single paper has been produced before the court that I was owner of that vehicle. And that vehicle was not insured at the relevant point of time. Regarding vehicle number WB335748, no document has been placed before the tribunal below. Either insurance policy before accident.
No, 5748, he's stating that there is no insurance policy.
Stating, but
How can he show? If he said that he does not have
before
insurance
that,
policy.
before the accident, it must be there.
No.
No, registration,
Question
whether
is-
he is owner or not, the registration was there.
No, the question is whether this vehicle met with an accident. Okay.
Yes,
That he has no papers. Okay.
he has no papers.
Okay. Another thing is this.
Whether he is owner at all owner or not.
That also, that question was not put to him.
I'm grateful to you.
Where is that question? That you have any papers to show that you are the owner?
My lord, when I am coming, I am stating that I am the owner. I am the owner. That I am owner of that house. I shall have.
Question is, you have not disputed his ownership. If you have doubt, you should put
My
cross
lord, I
examination.
am coming. I am coming.
Like one claims 5,000 rupees, no documents every time.
I am stating, my lord, I am owner of that house. I shall have to produce something.
You see,
This is civil dispute.
if you dispute, then only he has to prove.
This is civil dispute. This is not criminal case.
You have not put any cross examination that you are not the owner of that vehicle.
My lord, again, my lord, I am. And my lord, the OPW2 also has not produced anything regarding ownership of that vehicle. I have not filed any paper regarding vehicle number such and such. My lord, kindly see page 24, cross examination.
24. Yes.
Second line. Cross examination. I have perused the FIR charge sheet seizure list filed by the claimant petitioner. The alleged accident took place such and such at 7 p.m. Narayangarh Plaza. Then, my lord, I have not filed any paper regarding vehicle bearing number WB335748.
No, this is OP number 2.
Yes.
This is insurance company. How would insurance company will get the paper of 48?
Yes, my lord, kindly see. When insurance company told that vehicle was not involved, then, my lord, it is not possible for the insurance company. He has, my lord, he is the investigator of the insurance company.
Lord, how would I get the vehicle details of my learned friend's vehicle? I don't know.
It is all in the net.
Eh?
It is all in the net. And you have conducted inquiry.
Yes. Next.
The insurance company has not produced any paper regarding, my lord, regarding vehicle number WB33.
See, insurance company is confined only to this case. Either this vehicle is involved in accident or not. If this is involved in accident, insurance company will pay. If the insurance company has some materials to show that this vehicle is not involved, but some other vehicle was involved, but this
What vehicle was involved?
Yes, another vehicle was involved.
Another
Okay.
vehicle was involved. What vehicle was involved?
And
When
the insurance company has brought that vehicle owner. So what else is required? Your case goes.
Yes, its driver. My lord, I am coming.
Insurance company said that yes, this vehicle is not involved, other vehicle is involved. But how? By bringing that vehicle owner.
Yes, my lord. Kindly see. Paragraph 23. Anita Sharma. The observation of the High Court that the author of FIR, as per its judgment, owner cum driver, had not been examined as witness. Hence, adverse intervention ought to be drawn against the appellant claimant is wholly misconceived and misdirected. Not only is the owner cum driver not the author of the FIR, but instead he is one of the contesting respondent in the claim petition who is alone in the insurer company is an interested party with the pecuniary stake. He is this charge sheet has been given against him.
He said he is not denying that. He is stating, I am an offender. Okay, I have committed a mistake, but I was not driving X vehicle, I was driving Y vehicle. So he is admitting his guilt.
My lord, he is the interested witness.
And he is admitting the guilt. How
That has been stated in the my lord, before the police authority.
No. Question is in the court. He has stated
Yes.
that yes, the vehicle met with an. He may.
Or not.
You see, police authority has submitted charge sheet. Okay. Now in the court, he's admitting his guilt. Yes, that vehicle is involved in the accident. No, he was driving in a vehicle which is involved in the accident, but of course he is implicated. Mr. X is implicated, but the vehicle number is not correct. That is his contention.
That has not been produced before any authority.
Vehicle number.
That has been stated.
Okay, you see, if Mr. X is implicated for rash driving, he say yes, I am driving rashly, but not driving Tata Sumo, but driving Maruti. This is the thing.
Same vehicle, not my lord. Other number is different, but the nature of vehicle is same.
Where is that OPW1 has said?
Yes. Tata
And
S.
he has, you see,
Tata S. That vehicle.
This person has stated that
yes,
he was driving. He is the owner of the vehicle. This vehicle met with an accident.
Met with an accident. That is also Tata S.
Where?
Yes, my lord. Kindly see nature of vehicle. Nature of vehicle, page 46, my lord.
This is a summoned witness, okay. So the vehicle met with an accident. Okay, he is admitting that.
He is admitting that is also Tata S. In the FIR, my lord, kindly see WB 33E 1949 Tata S.
No. In his evidence, he has stated that regarding investigator.
Yes. While investigating.
No, was he arrested by the police?
Yes.
And produced?
Yes.
Any records of this criminal case? What did he say before the criminal court?
While investigator, my lord, kindly see. While investigator, my lord, page 20. That your lordship's, my lord.
Because you see, this deposition is 2023.
Yes.
And he has surrendered in 2021.
Yes.
Surrendered and obtained bail.
Investigator, while investigator of insurance company interrogated me at the time, I told him that the vehicle bearing number such and such. My lord, before that he has not told anything.
Yes. How did the learned trial judge deal with this issue?
Yes. My lord, page 30. Mainly, my lord, page 31.
Page
31, top. The main contention of argument of the OP insurance company is that the petitioner has not been able to bring any eyewitness of the occurrence of the accident, but the insurance company has not been able to establish that the death of Sheikh Halim has not taken place due to road traffic accident and more particularly the vehicle number WB 33E1949 was not responsible for the death of Sheikh Halim when the petitioner by proving FIR, charge sheet, seizure list and PM report has prima facie proved that the death of Halim has been caused due to rash and negligent driving of the motor vehicle. Evidence of OP insurance company not supported by any document do not bear any confidence when the FIR being such and such dated such and such charge sheet against the offending vehicle duly insured under the OP insurance company. That, my lord, vehicle number has come after interrogated by the investigator. Obviously, my lord, interested witness. And my lord, regarding interested witness, your lordship has seen previously Munawar Sai case also.
And how this person can be interested? He will not gain anything. He will be convicted. If his case is established, he will be convicted.
Yes, my lord.
He will not get the compensation.
After investigation, my lord, before the investigator, that
You see, whoever, when he is convicted, whatever be the case, of course, this there may be a benefit of doubt against him. If instead of this vehicle comes,
49.
He will get a benefit of doubt.
I'm obliged to my lord.
that is criminal case, not my lord in the civil case. My lord, paragraph 8.
Yes, paragraph 8.
The appellant may be right in contending that in case where the accident occurs without any fault of the owner of the vehicle or fault of the other vehicle, the liability to pay compensation at best must be determined in terms of section 140 as has been held in such and such. It is true that High Court in the present case has overturned the finding recorded by the tribunal that the motorcycle was driven by appellant number 2 at the relevant time when the accident occurred, and the instead concluded that motorcycle was in fact driven by deceased Krishna Kumar. Paragraph 8 and 9. Krishna Kumar, in fact, in that scene, the accident occurred neither due to the fault of the owner of the vehicle appellant number who admittedly was not present or traveling on the motorcycle at the relevant time, not due to fault of any other vehicle. However, on a deeper scrutiny of the materials on record, we are of the opinion that the High Court committed manifest error, an error apparent on the face of the record in reversing the finding recorded by tribunal that the motorcycle was being driven by appellant number 2 and had caused accident due to rash and negligent driving. We are conscious of that fact that the respondent claimant have neither come up in cross appeal against the reduction of the compensation amount on the finding of contributory negligence, nor have they filed any cross objection regarding reversing of the crucial finding of the fact High Court. However, it is well settled that motor accident claim case, the court cannot adopt a hyper-technical approach but has to discharge the role of parents parties. This appeal being continuation of the claim petition at the instance of the owner, alleged driver of the vehicle, we consider it appropriate to examine the approach of High Court in reversing the finding of fact recorded by tribunal on the factum of motorcycle being driven by Premlal such and such at the relevant time, and also that he had caused the accident due to rash and negligent driving. We are inclined to do so. It is open to the respondent to support the decree while urging that the finding against them recorded by High Court on the matter in issue ought to have been in their favor as he has been held by tribunal. And thereafter your lordships will find paragraph 9, that bottom portion. Kindly see paragraph 9 bottom portion. The appellant did not even produce any little evidence except bare words of the appellant and their witness Narendra Manika DW2 and Joy Prakash DW3, who are obviously interested witness. And your lordship knows the decisions of Rajini Sahu. My lord, the charge sheet FIR cannot be thrown out. After perusing this, your lordship has passed several decisions. Paragraph 8 and 9. I shall not take much more time. Regarding income, only one, my lord, decisions of the Honorable Apex Court. My lord, here the number of claimants are 4: wife, minor, and parents. And my lord, their dependency has been proved by adducing evidence. By adducing evidence. Has been proved by adducing evidence. My lord, kindly see paragraph 5.
Yes, I shall see.
My lord, one advantage he would get more if at all my lord is in his favor. My lord, the multiplier, my lord, learned tribunal judge has granted 17. It would be 18. My lord, I have made calculation by giving multiplier of 18. By this, my lord, he will get. So, my lord, future prospect I have given extra. Multiplier I have increased. And by my lord, 5,000, it comes to 10 lakh, my lord. That is, my lord, it is more than 2,10,000 rupees than what learned tribunal judge has granted. This calculation.
In the claim petition as well as evidence, my lord, I have claimed 15,000 per month. My lord, kindly see here, my lord, paragraph 5. Only I shall not take much more time. On the aspect of quantum of compensation, it is noted that the claim as put forth by PW1 and PW2 is that the deceased was working as a mason and was earning about 15,000 per month. It is no doubt true that there is no specific evidence with regard to the income of the deceased. In a matter of the present nature, where the deceased was working as mason, it would not be appropriate to expect any documentary evidence. However, taking into consideration the avocation of the deceased, the year of accident being 2013, in this case, my lord, year of accident 2021, renocking the daily wages 3,000 can be 300 can be the said to be excessive, cannot be said to be the excessive. In that, if that be the so, the monthly income of the deceased could be renocked 9,000 plus 40% future prospect.
Yes, but so far the age is concerned, it is difficult to believe that he would be capable to work as a mason.
But he was during his lifetime, he was maintaining
He's
his
22 years of
yes,
age.
22 years. But
Maybe some other work he used to do.
yes, my lord, he was
And earn
maintaining his
something.
family. In 2021, your lordship knows that the socio-economic condition. In
Yes.
2021, your lordship knows the socio-economic condition.
Yes, 2021.
Yes.
But this,
And my lord, he was maintaining his family.
his parents were there, brothers, sisters were there, everybody was there.
No. Number 4. No. 4 persons are, my lord, the claimants. Wife, minor, and parents.
According to them, the age was 21 probably. 21 or 22?
22.
22.
21, 22. In between 21, 22.
Very difficult to
In
believe.
my lord, he was maintaining his family.
That he was a skilled worker.
My lord, your lordship will kindly see the contradictions. My lord, when the evidence is there before the court with regard to the witness, the driver owner, he says, forget about that. Go for the documentary evidence, charge sheet, FIR. Don't believe the person who is coming before the court, who is the owner of the vehicle, who is the driver. So don't believe his testimony. And then,
regarding beyond pleading, this is regarding beyond pleading.
At the time of filing of written statement, I didn't have these details with regard to this evidence of this the owner driver. Written statement is to be filed within a stipulated time. I had no idea. I have asked him the policy particulars that is also there in my written statement. I didn't even have the policy particulars of 49. So, my lord, why is he referring to, my lord, the written statement? I have said, give me the particulars, give me the particulars. Therein I have specifically asked for. So, what I was submitting, when the evidence is there, the learned friend's submission is forget about the evidence before the court. We better rely upon the documents. And my lord, when there is no document with regard to the income is zero, then says forget about the documents. What I say in the witness box, please believe that. See the contradictions, my lord.
You see, there are some occupation where you cannot have documents, but you may have some corroboration.
My lord, I was submitting about the contradictions in submissions. When, my lord, the evidence is there, when the person is in the witness box, the submission is made before the court that forget about that evidence. Your lordship will fall back on the written complaint. Totally oblivious of that person who is standing in the witness box, my lord, and who has faced the, my lord, this cross-examination, and he has stuck to that in the specific questions. And then, my lord, when as far as the income part is concerned, then says no document, forget about that. The one who is in the witness box believe that is income. So, my lord, look at the, my lord, this contradictions, my lord, in submissions here. Whatever suits him, my lord, he says that accept that, leave the other. Whatever suits, my lord, at one place it suits, my lord, A suits him. He says the submission is please take A, forget about, my lord, B to Z.
That means if you read the decisions, we have to read the facts of the case
Lordship,
also.
I'm extremely grateful
Not
to your
a
lordship.
particular
I'm
paragraph.
grateful to my lord. I mean, it is always, Supreme Court has always said, the person who is standing in the witness box, he will always carry more weight than the documents being produced before the court. It is absolutely clear.
Before my lord, it is also fact, but not before delivering of the
Yes,
written statement.
learned advocates for the parties are present. Heard learned advocates. Hearing is concluded. Let this matter appear for judgment on 5/8/2026.
5/8/2026. Deep blue October.
Yes.
Next item, special effects matter at 12:30.
Yes, yes.
Can
If you are ready in the second half, if time permits.
My lord, it was the last chance today. I am ready for argument.
My lord, I was from 12th. My lord, your lordship, after your
Also,
My lord, I am ready for argument. My lord. We can do the argument.
I'll keep it on this Friday.
Friday, my lord.
Yes, learned advocates for the parties are present. No time today.
Right, my lord, Thursday, my lord, Friday, I am engaged.
Thursday, Thursday, other matters are fixed. For Saturday?
Saturday, my lord.
Okay, let this matter appear on 1/8/2026 at 12:30 p.m.
12:30.
Grateful to your lord.
I have tried at my best, my lord.
দুটো 20
in misleading.
Yes. Hence, it is ordered that the appeal FMA 374 of 2024, there was any court. Yes, along with stands disposed, the judgment and award dated 19th July 2022 passed by learned additional district judge first track first court Barashat North 24 Parganas in MSC case number 805 of 2012 stands modified to the extent that the respondents claimants are entitled to rupees 24 lakh along with interest at the rate of 6% per annum from date of filing of the claim case till today. The appellant Oriental Insurance Company Limited shall deposit rupees 24 lakh along with interest at the rate of 6% per annum before Registrar General High Court, Calcutta. Such deposit shall be made within 8 weeks from the date of communication of the order. In the event compensation awarded by learned trial court is deposited, no further deposit be made. The respondents' claimants will be entitled to withdraw the compensation upon compliance of necessary formalities. The balance amount, along with accrued interest, be returned to the insurance company. That's good. Yes, call the fixed matter.
But in this matter, I am appearing for the appellant. Before my learned friend begins, my lord, I want to indicate I filed an application which is appearing in my lord's list as can number 7 into the 11. This application is for restoration of the interim order which was subsisting. If my lord kindly comes to, I have explained, my lord, why the interim order could not have been extended. It was it was my latch actually, my lord. I could not have.
You have served copy?
Yes, yes. Yes, yes. I have served the copy, my lord. The interim order was still 1 week after Puja vacation, last Puja vacation. That was 3rd, and the matter appeared much after on 13th. So that day I should have pointed out to my lord, which was not done. I have explained in paragraph. If my lord kindly comes to page 7, paragraph 19.
No, I have no objection with respect to this.
Okay. Yes, let's hear out the appeal.
Yes. My lord, just to remind your lordship, my lord, kindly have a look at the substantial questions which have been framed, and I shall, my lord, only restrict my argument on that and nothing else.
The original appellant died.
Yes, my lord. Yes. Yes, sir. It's a very. I'll try and finish within half an hour. Kindly turns to below 130 of the paper.
Mutata.
129.
Yes.
No.
The order dated, my lord, 25th of April, 2023.
Yes.
That was the order, my lord, by which the appeal was admitted, and, my lord, substantial questions of law were framed. There are 2 substantial questions of law. One, my lord, is whether the first appellate court has substantially erred in law in misappreciating the evidence with regard to the reasonable requirement, in reversing the judgment and degree of the learned trial court, and the other one, my lord, is partial eviction.
Yes.
Now, my lord, may I most humbly, my lord, address your lordship on partial eviction as my learned senior friend has argued. My lord, my first respectful submission is partial eviction, if I'm not mistaken, was not argued anywhere, neither in the trial court nor in the appellate court. Partial eviction, my lord, is a question of fact, primarily.
So was evidence adduced with
Yes,
regard?
towards partial eviction, no. Nor pleaded, nor proved, nor argued, and for the first time, my lord, in the second appellate court, this was taken as a ground. Now, my first reaction, my lord, to this ground is that, my lord, it is, your lordship knows, I can tell before your lordship that this is not a substantial question of law. My first point is, my lord, that this second point is not a substantial question of law for the simple reason, my lord, there needs to be a fact. Partial eviction is basically on fact. Firstly, they will have to show, my lord, by way of partial eviction, I am able to, my lord, or rather, my 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 lord, requirement is being able to be satisfied by, my lord, their partial eviction. They had to tell the court that, look here, from the evidence on record, by my eviction, by his eviction, my lord, my requirement is met. Where does partial eviction come into play, my lord? May I most humbly, my lord, make this submission before your lordship. The requirement of the landlord is, my lord, 2 rooms. The tenant is in occupation of 6 rooms. So by way of partial eviction, those 2 rooms, my lord, go to, my lord, the landlord, and his requirement is met.
And it is a flat, not a house.
Exactly. So grateful on that. So today, the flat, if the flat is taken away for my, my lord, by, say there are 3 rooms inside the flat, they mean to say, my lord, there will be my managers and they together, my lord, staying in that flat. Is that possible, or is that allowed in law? May I ask this question to myself? So grateful that, my lord, your lordship, my lord, opined on. Partial eviction can only be possible when there are, my lord, separate, completely separate rooms from which the tenant can be evicted and the requirement of the landlord is met. Have a look at the schedule once. Kindly turns to, my lord, page 1 of the, my lord, the compilation that we've given your lordship.
Compilation টা
একটা compilation দেবে জজ সাহেবকে? সাহেব কোথায় গেল? এইটা স্পাইরাল বাইন্ডিংটাই তো compilation.
Yes.
Looks to, my lord, page 1, and for the schedule, kindly have a look at
Compilation. No, here it comes from page 220.
I'm so sorry, my lord, it should be the compilation. হ্যাঁ গো, সাহেবকে একটু compilation-টা দাও না।
আগের ভলিউমটা দিন।
আর ওটা বোধহয় না, এইটা বোধহয়। এটা 1 থেকে 220 আছে? 219 আছে?
1 থেকে 219 অবধি।
দেখো উপরে লেখা থাকবে। হ্যাঁ? 11 বলো, পেজ নম্বর 11। প্লেনটের শিডিউলটা কিনা দেখো। 1 থেকে 180 আছে। আচ্ছা, দেখে জজ সাহেব থেকে। প্লেনটের শিডিউল আছে? হ্যাঁ, তাই আচ্ছা। না, ওটা না। পেজ 11 হবে। 11 এর শিডিউল নেই তো, ওটা তো লেখা।
নেক্সট পেজে যান, নেক্সট পেজ।
আরে সামনে ইন্ডেক্স করা থাকবে, দেখো না।
ইন্ডেক্স বলে লেখা আছে 180টা পাতা।
180টা পাতা হবে। কম্পাইলেশন তো এটা নয় মনে হচ্ছে। এই দীপরাজ বাবু, হ্যাঁ কম্পাইলেশনটা করতে হবে। ওটা পেপার বুক, তার একটা কম্পাইলেশন থাকবে।
দেখি 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 ওটা।
এইটা হচ্ছে এটা, হ্যাঁ হ্যাঁ ওটা নোটটা কার চলে গেছে দেখো, ওটা সাইবেরই নোট হবে। হ্যাঁ in this the plane starts from
Yes,
page
page 1 to 130.
Yes, I'm so grateful. Kindly turns to page 11. That's the schedule of the plane.
Yes.
Sees below, what is the schedule? Flat number 1A on the first floor of Neelkant building, measuring about 1,606 square feet, more or less together with 300 square feet, lying situated at and comprised in municipal premises number such and such. So it's a flat of 600 square feet. How many rooms? That's later, my lord. If your lordship sees about my eviction of, rather, I'm sorry, by reasonable requirement, kindly have a look at page 6. B. Why I need the premises. That the plaintiff reasonably requires the suit premises for its own use and occupation, which they intend to use in the manner in hereinafter stated, and the plaintiff has no other suitable accommodation elsewhere. The plaintiff is at present carrying on business as a non-banking financial corporation from their aforesaid office at 8 Kamak Street. The plaintiff has 9 members of staff and employees in the organization, including a manager and an assistant manager. In terms of the service contract, the plaintiff is to provide residential accommodation to the senior staffs, namely the manager and assistant manager. Since the plaintiff has no such accommodation of their own for providing the residential accommodation to their senior staff members, they are providing such accommodation in a rented accommodation on 11 months leave and license basis, for which the plaintiff has to incur huge amount of costs towards payment of rent license fee every month. Therefore, documents evidencing such is annexed. The plaintiff, in accordance with the object clause of its memorandum of association, has resolved to diversify its real estate and iron and steel business. The plaintiff, with the object of doing real estate and iron and steel business, is increasing its manpower by recruiting more senior staffs and is under an obligation under the service contract to provide residential accommodation to such senior staffs, namely the managers and assistant managers. For starting real estate and iron and steel business, the plaintiff's director and promoter have already invested a sum of 2.5 crores by way of share capital during the last 2 years. Since the plaintiff is required to provide accommodation to the manager or assistant managers free of cost, the plaintiff, in spite of having ownership in respect of the suit premises, may not kindly marks this, that this property is owned by me, there is no dispute on that. Has to incur huge amount every month towards payment of rent, license fees and other charges. More so, the aforesaid rental accommodation to the manager or assistant manager is always vulnerable to threats of eviction from the landlord. Accordingly, the plaintiff requires the suit premises for providing residential accommodation to the managers and assistant managers, for which the suit premises is very much a suitable accommodation for their own use and operation. Lord, this is my reasonable requirement, why I need it. Lord, your lordship need not look at any other point for the moment, because we are only on reasonable requirement and nothing else.
The default did not succeed.
Nothing. We are not on that. So my requirement, my lord, of this property is to only for the benefit of my employers. It is my property. I have a right to, my lord, keep just the way I can, my lord, in a normal landlord-tenant relationship. Your lordship will find the landlord files a suit for the benefit of his son, for his daughter, for his whoever's dependent, all lives with him. And he is entitled to that. Here, my lord, my property, my business, everything is mine. And I am to give accommodation, my lord, to my employers. And I have a flat of my own. But I am, my lord, giving that, my lord, whatever that's the facility or the perks, as they say, my lord, in common language, to my employers, but I am paying through my pocket, even though I am owning, my lord, a property, which can, my lord, satisfy, my lord, my requirement. Now kindly have a look at their written statement about that. It starts from page 31. And the relevant portion, my lord, your lordship, I'm not troubling your lordship with the entire. Kindly looks to, my lord, paragraph 18. I'm sorry, not 18, 19.
Paragraph 19 of the written statement.
It is at page 37.
Yes.
My lord, his defense is, apart from the usual that's written, my lord, denying whatever I stated. The defendant states, it's at page 38, the first paragraph, about 5 or 6 lines from the top. The defendant states that the leave and license agreement annexed to the petition are fabricated. My lord, can you got that? About 7 or 8 lines from the top. 8 lines.
Yes.
So his cases, his positive case which he needs to prove is that the leave and license agreements which I have produced below are false and fabricated. That's the onus is upon him to prove, not on me. Then Millard kindly Millard comes down. It is denied that the plaintiff with the alleged object of doing real estate, but he denies that. I do not know Millard, how the tenant can dictate what I will do in my life. Senior staff, it is further denied that for real estate and iron and steel business, Millard, your lordship need not trouble my lord self. It's just a normal denial of what he said. Then the turns to 39. This might be a little relevant for mine. He is director of many.
Page 39.
39. Top. First line. He is director of many other private limited companies such as Arian Commercial Private Limited, Ankita, Lord Real, Mona Lisa, and other private limited companies. Mr. Arun Kumar Sancheti has a big office being room number such on the 5th floor at Shantiniketan building, 8 Kamak Street, Kolkata 70017. He has offices of all the group companies situated in the said office. The said companies are carrying on real estate business and they are constructing buildings in and around Kolkata, and as such, question of dearth of accommodation for them does not and cannot arise. Milord, your lordship knows, I need not, Milord, trouble your lordship, but just to remind your lordship, Milord, I might have thousands of houses all over Calcutta, but the reasonability that I need that premises which is suitable for me. The suitability, my lord, is the most important thing, my lord, which your lordship would take into consideration at the time of deciding whether I need the property or not. Now, my lord, I am not even going into the question that all these properties that he has said belongs to other people. They are not my properties. It might be, my father might have a property, my son might have a property, the other companies might have a property. Exactly. Obviously, I'm sorry, my learned friends are very particular about what I say. My father means, my lord, the company can't have a father. The director's father, my lord, has a company. Now, they wanted to, my lord, mix the two. Why I said my father, my lord? They wanted to mix the two. The plaintiff, though, my lord, the company has a separate juristic entity, but even if you want to lift the veil and you want to say that that the director has something, director has this, director has that, director's property doesn't belong to the company. That is director's personal property, not even the director's father. This is their allegation. So, my lord, I have a flat at Kamak Street, which I can use to, my lord, give it to my employees. But they are saying, no, you are into real estate business, so you have a lot of other properties. Haven't been able to prove even one. That I will show. My lord, they will have to show that the plaintiff has a suitable available property, my lord, which satisfies my needs. The plaintiff. My lord forgets about the fact that the plaintiff, my lord, is a company. Take it for instance, my lord, that the plaintiff is a human. If a plaintiff is a human and the defendant says that the plaintiff's father has a property, so his requirement is met. Your lordships have deprecated that, not in one decision, but thousands of decisions. Kindly seize below the statement, the written statement. They are very specific there. Mr. Arun Kumar Sancheti has a big office being room number 503A on the 5th floor at Shantiniketan building, 8 Kamak Street, Kolkata 70. He has offices of all the group companies situated in the said office. The said companies are carrying on real estate business and they are constructing buildings in and around Kolkata. So are they suggesting, below, that I give up, below, my office space so that, below, my employees can come and stay there? They themselves demolish, below, their own case, in my respectful submission, because they are themselves saying that the property which the director has is being occupied by the office space. So they themselves, below, they do not say that it's empty or it can be used. What is my purpose? My purpose is the residence of my employees.
To accommodate the employees.
So they themselves are, my lord, in their own written statement, by their own written statement, demolishing their case. They had to show, my lord, that I had an available property where, my lord, my employees would have gone and stayed. Kindly see, it goes on even more interesting. The said companies are carrying on real estate business and they are constructing buildings in and around Kolkata, and as such, question of dearth of accommodation for them does not and cannot arise at all. He has flat number 10B, 10C and 10D in Neelkantha building itself. The flat number 10B and 10C are in the names of Arun Sancheti himself, and flat number D is in the name of Sancheti Projects. They are demolishing their own case. They are not for a second saying, my lord, that these are empty flats. Take it for instance, my lord, it belongs to SN Alloys. But are they saying, may I ask this question to myself, that these are empty places where, my lord, the employees can go and stay? No. They are saying I have, and the business is on.
Yes.
Then, my lord, the very vaguest of vague statements, the defendant states that the plaintiff has several other properties in and around Kolkata. The ground of reasonable requirement taken by the plaintiff is a concocted one and has been fabricated and for the purpose of evicting a bona fide tenant. The story made out is baseless. So they will have to prove, the onus is on them to show, Miller, that how many properties I have. Miller, by a click of a button, Miller, it would come out. The court will have to see the existence of those properties and then the suitability. Now, Kylie sees how, Miller, they have proved this, if at all. Kylie looks to, Miller, the cross of DW1.
That is.
Which starts off, Miller, at page 17.
Anyway, these are all matter of fact cross of.
So bow down.
Cross of
But,
DW.
but they are the first, below the substantial question of law is misappreciation of it. So I want to show your lordship the evidence if at all. There will be misappreciation when there is evidence.
Evidence, and that is again reappreciated by the appeal court.
I bow down.
Now you see.
First appellate court can.
Yes.
Under 96, he can reappreciate evidence. But the substantial question of law is, Lord, that there was a misappreciation of evidence, which I will
By the
show you.
appeal court.
Yes. So I will have to, that misappreciation will come in only when there is any evidence on record. But at the time of admission, the respondents don't have a right to say anything. But later, now I can show your lordship how vague that point of law has been, Lord, in any manner.
No, there was an application to adduce evidence, that is commission's application was there.
Yes,
filed
yes.
before the appeal court.
Absolutely. Lord, it was not taken up. First appeal court, we did that because for this suit property.
It was taken up along with the hearing of the appeal.
It was not, Lord.
It was not necessary. Along with the hearing of the appeal.
Absolutely. And it was not necessary. Even today, I say, Lord, it's not necessary. Because we have admitted whatever the entire thing we have. There was no necessity, my lord, of another inspection. When does inspection come in? When there is a dispute with respect to the extent of the property.
That is why you see this application and the appeal were hard out together.
Absolutely. Absolutely. I bow down. So now I am telling your lordship, Lord, with vis-a-vis the substantial question of law, which is misappreciation of evidence, kindly sees if there is any evidence at all or not. I am on that. Reappreciation, appreciation will come in, misappreciation will come in only if there is evidence. Sees what is the evidence? 78. Others I am not troubling your lordship. Cross-examination is important. Okay, DW. 80.
PW1
8. I'm sorry, my lord. 90. I have not 90.
cross-examination.
Lord, I'm sorry, it's my mistake. That's PW1, they are right. Kindly turns to page 90. Very importantly, kindly sees who is giving evidence.
Page 19.
87.
Page 87.
Kindly starts off with 87. Because I want your lordship to see who is giving evidence.
Yes.
The tenant has not come forward to give evidence. It's the tenant's wife. And why, my lord, it's important? Fine, I understand, my lord, that the wife knows everything that the husband knows as a presumption in law. But why I am a little skeptical about it is...
This original appellant passed away.
Yes, that was much later. I will show your lordship why I am showing your lordship this. She is not giving evidence as a wife. She is giving evidence, my lord, as a constituted attorney. Kindly have a look at page 87.
Yes.
So she doesn't take into account, my lord, that she's the wife. Under the law, there is a presumption that whatever the husband knows, the wife would know. There is presumption. It's rebuttable, but there is a presumption. But she's not giving evidence as a wife. She's giving evidence, my lord, as a constituted attorney. Once she becomes a constituted attorney, my lord, she can only say whatever she has been told by, my lord, the main person. She can't go beyond that. She can't have personal knowledge. And even better is why I say, my lord, take it as an adverse inference, is kindly comes to, my lord, page 90. First line. First line.
Yes.
It is a fact that Mr. Texwansio is in Kolkata. He is in Calcutta, but he doesn't come to the dock to prove his case. This is my first point. Then kindly sees, then kindly comes to, my lord.
My lord, sorry to interrupt. If my lord sees 1, 2, 3, 4, 5, 6 line, it states that my husband is not physically fit.
Anyway, that is there. Whatever is there, it will be considered.
That's why I first showed your lordship about constituted attorney. And that's why I showed your lordship. If he's not physically fit, there are different ways of doing things. I am not advising my learned senior friends at this moment of time in second appeal. But there will be an adverse inference in my respectful submission. Then, kindly comes to about 2 paragraphs from there. I did not file any documents or medical certificate of my husband in respect of this current date. We had a date in November, or just the line above, since my learned senior friend talks about it. We had a date in November and my husband could not attend court, so I had filed medical certificate. I did not file any document, medical certificate of my husband in respect of this current date. Not a fact that my statement that my husband is not physically fit is false and concocted. In fact, Sudha Beg was the original owner, but your lordship need not trouble my lord's self on that. 7172 has been spoken over. Kindly turns to 92 bottom.
Page 92.
Others are more your lordship about her qualification and employees and things like that. I don't.
Yes.
One part might be interesting is that they admit about the people who were just for 1 minute. I have no idea. 4 lines from the top. I have no idea if there is any restriction in the company in the matter of granting power of attorney. I said that the transaction is a sham transaction because Naveen Kumar Sethia, who is one of the directors of Rosewood, acted as the constitutional attorney of Sudha Bed, the vendor, and he is also an employee of S&M Alloys, the plaintiff company, and he is also one of the directors of conforming party, which is Rosewood. Voluntarily says Naveen Sethia acted on behalf of the vendor and the purchaser at the same time. He's one of the director of Rosewood. After that, lordship need not trouble my lordship. Then comes down, my lord, to the last paragraph. I do not have any documents to prove that the plaintiff company is not required to prove residential accommodation, is not required to provide, if I'm not mistaken, my lord, to the senior staff manager and assistant manager. Not a fact that the statements made in paragraph 23 of the examination sheet are mere surmise and gesture. Voluntarily says they are my belief. Then turns to the next page, my lord. I do not have any personal knowledge in respect of Exhibit 16 series. Not a fact that I stated falsely that Exhibit 16 series has been manufactured for the purpose of this suit. Because what is that Exhibit 16 series, your lordship knows, is those documents with respect to those that my employees are my employees and the leave and license agreements and so on and so forth. This is what is, my lord, the proof. My lord, Exhibit 16 series, my lord will find. I'll show your lordship from the last. It's ডিগ্রিতে না এতে ওই তুই বলি কালকে ছিল এই পেজগুলো বল yes kindly looks to blood from page 85 onwards একবার এটা দেবে ওই অরিজিনালটা একবার দেবে ট্রায়াল কোর্ট রেকর্ডটা হ্যাঁ ইউজলেস অনেক ডকুমেন্ট আছে সেটা সত্যি blood it's better your lordship looks from the
85
yes 85 onwards your lordship will see but it's in the it's not there because the exhibit has a different list altogether
Oh,
এটা
list of
আলাদা করে করা
exhibits.
ছিল? তাহলে এলসিআর থেকেই দেখাতে হবে। তাহলে এইটা একটা দিয়ে দে না জজ সাহেবকে।
No, list of exhibits you have filed a compilation.
I have filed a compilation for ourselves, but your lordship has a look at it because it's tedious there. And I will make one and give it to your lordship again. So from 85 onwards, your lordship sees them. And these are all facts.
Right, this is the appointment letter.
Yes. All throughout from 85 onwards, your lordship will find exhibit 16 series. Kindly quickly have a glance. But they say that I do not have any personal knowledge in respect of exhibit 16 series. Kindly remembers the defense case. Kindly remembers the defense case. False and fabricated. ঠিক আছে, ঠিক আছে। ওরা তো ওই পুরো ডকুমেন্টেই তো বলেছিল। The exhibit 16 series, my lord, your lordship will find from 91. Kindly remembers, my lord, false and fabricated. And in cross, she says, I have no personal knowledge.
No, he who alleges fraud must prove
Must
it.
prove fraud.
Mere saying is nothing.
And he's saying, I don't have personal knowledge. Need not trouble your lordship any further. This is it. This is the matter.
So
Then kindly sees
that is page.
that even.
Okay.
Now, lordship comes back to the cross examination. Page 95. Nothing but a desperate attempt to hold on to my property forever. Mother, can you go ahead?
Yes.
95. I read the first paragraph. It is a fact that the second paragraph. It is a fact that the names of the companies which are mentioned in paragraph 26 of the written examination, in chief, all those companies are engaged in real estate business. Nothing turns on them. It is a Miller. I do not know why they stopped at only those companies. They could have added 20 other companies as well. It is a fact that the business of real estate deals with developing and constructing, building and selling the same. I do not have any idea about the register of companies. I agree that SN Alloys and Sanchiti are different companies. Marks this.
Yes.
And they themselves are demolishing their own case. I don't have to do anything. Flat number 10D stood in the name of Sancheti Projects Private Limited. This is their admission. Different companies stood in the name of Sancheti. But even if it stood in the name of Alloys, they had to show that it's empty and it can be used for my employees. They can't say how I will run my business. I am running my business in my own way. I want to give these facilities to my employees. They can't come up and say that, look here, you can't do that. You might be the owner of the house, but you can't do what you want to do. I am there, I will stay there forever. This is completely.
No, the suit room was required for this managers in general or specific for Mr. X and Mr. Y?
General.
In general.
Absolutely.
Okay.
It is not for one person. Their employees will change.
Okay.
Today, Mr. X is in employment. Tomorrow, Mr. Y will be in employment. That is why, in the plain case, it's made out that it's for my employees, not for that particular employee, managerial employee. So today, I might be the manager. Tomorrow, somebody else will come, who's a better person. He will occupy it. This goes with his employment. Then, kindly marks these two statements which are very important. That is the plaintiff company is that they are different. SN Alloys and Sancheti are different.
That is page, yes,
95.
95.
SN Alloys and Sancheti Projects are different companies. Flat number 10D stood in the name of Sancheti Projects Private Limited. Then also, my lord, there is another admission. It is a fact that SN Alloys Limited, that is the plaintiff company, is represented by board of directors. It is a fact that SN Alloys is not a proprietorship concern. Not a fact that I am deposing falsely. That's the usual thing that your lordship in the trial court people, the advocates ask. So this is what it is. Why I showed your lordship this? 103. Milord, there was a further clause. I'm grateful to my learned friend. I had forgotten about this. At 103. I'll read this for your lordship.
Yes.
After my cross-examination was closed, while perusing the documents, I found that Naveen Sethia had mentioned his residential address as Atto. So I searched the net to find out whether the same was mentioned in the other documents or not. The office address of Vinayak Villa and Khazana tie-up at 8 is at 8 Kamak Street, 5th floor, room number 3A. It is a fact that Mr. Sethia is one of the directors of both the above-mentioned companies. I know Shantiniketan building. I cannot say if Shantiniketan building is used entirely for commercial purpose. I do not think that Mr. Sethia uses the address for the purpose of correspondence only. It is a fact that the residential address and the office address of Sethia is the same. That is 8 Kamak Street. I do not have any personal knowledge whether Mr. Sethia resides at room number 3A, 5th floor, Kamak Street, which is completely irrelevant. Not why I wanted to show your lordship is, it is their case that I have lots of properties around. There is no document on record. There is no evidence on record. So the question of misappreciating evidence doesn't arise at all. তো আবার বলছি your lordship remembers they had admitted that SN Alloys, Sancheti are different companies. There is not even a statement saying that SN Alloys owns another property, Milord, in the vicinity. Not a statement. Forget about, Milord, any other properties. Not even a statement. And the substantial question of law is misappreciating evidence. I don't know, Milord, if Mr. Mukherjee.
Now, in this particular, this building in which a flat is occupied by this appellant, the other flats are occupied by whom? The outsiders?
Many people, Milord.
Many people. That means not all are employees.
No. Milord,
Only that flat is the company's flat or entire building?
No, only that flat.
Only that flat.
Shantiniketan building, Milord, is a huge building. Once your lordship goes through, Milord, Kamak Street.
Shakespeare Sharani.
Kamak Street.
Kamak Street.
It's a commercial, residential cum commercial building.
Okay, so that flat belongs to company.
Absolutely. Different.
And in which building was this commission sought for?
In the other flat, which is occupied by the director's father.
Okay, that is in which area?
The same 10B and 10C of Shantiniketan.
Okay, for which you wanted to adduce further evidence before the appeal court?
No, we wanted to adduce, Milord, with respect to the suit property.
Adduce evidence with regard to?
Suit property, not the.
No, commission was sought for with regard to which property?
The suit property. 10B 10C তো সুটে হয়েছিল। এই জজ সাহেব জিজ্ঞেস করছেন অ্যাপিল কোর্টে যেটা আমরা ফাইল করেছিলাম সেইটা কোর্টটা আমরা করেছি। আমি সেটাই তো বলছি suit property. It was not needed. Milord, your lordship remember.
Suit property is that only flat.
Agreed to. That's why it was not needed. But there was, Milord, one judgment of Justice Chatterjee which said Reasonable requirement, you will have to, but there must be a local inspection. That's why probably they were a little afraid. So for abundant caution, they wanted it. But
But at the appeal stage,
absolutely. So the
no reasonable requirement, you see, a suite room, a flat is being occupied, okay. So flat is being occupied, only the question may come with regard to partial eviction. But reasonable requirement means what? How many things you are in possession, how much you require. So that is not in your possession. So unless you get inspection of your other rooms, so
absolutely, I completely bow down to your lordship. So what they have to show is X is a property belonging to SN Alloy. Apart from X, there is Y, Z, Y, W, A, B properties of SN Alloy.
and
Why?
your application was confined to suite building,
Only
suite
to the
room.
only to the suite room, so a suite flat. So that is not superfluous. I am saying it was not required at all, because the extent of that flat is not in dispute. If the extent of that flat would have come in any way to the assistance of my learned senior friends clients, I would have understood. Or to my client, I would have understood. It is not in dispute that flat, how many rooms are there and how many rooms they are in occupation. It is not in dispute. If I had hidden a flat, say Milord, the question is with respect to Milord Shantiniketan building at 8 Kamak Street. Suppose I had a flat at 9 Kamak Street and I had hidden that and I suppressed that. That would go against me. Then there would have been an inspection. Then partial eviction, then whatever Milord would have come into play. Here, what they allege is, apart from Milord, this is probably 10A, I have 10B, 10C. But they forget 10B, 10C doesn't belong to SN Alloy. 10B, 10C belongs to somebody else, and that's their own admission. That is what they have said, Milord, in their cross-examination. And they say, I have so many properties, but fail to prove even one. So the question of misappreciation, Milord, in my respectful submission, is completely bereft of anything. Now comes, Milord, the question of partial eviction.
That means, according to that should go in favor of the respondents.
Has to, Milord, in my respectful submission. Has to. If they can't prove what they allege, has to go in favor of, Milord, the plaintiff. Today, Milord, I can say I am the owner of 20 properties. My saying doesn't become, Milord, that I am the owner. By saying that I am into real estate from before. By saying I am real estate from before. How, Milord, may I ask this question to myself, how is it a crime? I have to be suitably owning something else so as to meet, Milord, my requirements. Not proved. But they want to. This gives me a second. বলছি তো আমি আমার উপর নেব কেন, আমি তো তোরা কেন ফলো করছিস না? হ্যাঁ, আমি বলছি যে ওরা প্রুফ করবে তো। But they want to say factually about my positive case. In my balance sheet, Milord, it's always one property. There's not more than one or two or three or four properties. But they've alleged it. They've alleged it. I have not. Why should I prove the negative? Milord, may I ask
Oh,
this
if
question
you
also?
admit, if there is an admission
Definitely
that property is yours, then there should be a commission.
Milord, I bow down. I bow down. But now the Supreme Court has become even more lenient. It says that if a property is not in the vicinity, or it does not in any manner come to the aid of a tenant to prove that the landlord has suitable alternative accommodation, no, the commission itself is not required. It's only
The
time.
trial court's observation is that you have failed to prove your reasonable requirement.
Very, very interesting. Can you have a look at it? There are ways that one can deal with a situation, but just because I want something, I want to do something, a court can't do that. A court has to, Milord, in my respectful submission, restrict itself to the evidence on record. That is why, Milord, we are always taught that the statue of the my lord, the person giving justice is blind. My lord needs to be blind. So whatever is on record, it's like a horse. Whatever is on record, of course, when your lordship wants to do justice, that's a different thing altogether. But if on record, the evidence shows that what they are saying, my lord, is not correct, then justice needs to be done to both parties. My property, my lord, I want to enjoy it. He's a tenant, my lord. Forget about everything. If I want to play football there, my property. My lord, when was tenancy, my lord? The 1956 Act was enacted, or 1997. Your lordships will see the difference. 56 was pro-tenant.
No, this is also a welfare legislation.
This is not. Now, after this judgment from, my lord, I forget the name, I'll tell your lordship, Nasiruddin's case.
Yes.
Your lordship will find the Supreme Court is saying that 97 is not just pro-tenant, not welfare legislation. It is also for the welfare of the landlord.
But if two views are available,
even then it says it goes to the landlord, because the property belongs to him.
So where two views are available.
Here, below, there is no two, there is not even below 1.1 available.
Anyway, I think after today, anyway, you may conclude today. I think one more question of law can be formulated.
My lord.
Anyway,
They have not prayed for, kindly do not formulate it.
No, you see, in other matters also I have formulated.
Your lordship has. There I prayed.
Yes.
I prayed. Mr. Mukherjee did not pray.
Let us see.
If your lordship wants to, I will not stand in the way. If your lordship wants to, my lord, kindly frames it, I will answer it.
Yes, yes.
But then Mr. Mukherjee has
So
to
do you want to, because even the moment I frame it,
my lord,
you cannot conclude today. You have to conclude on some other day.
kindly frames it. Then I'll finish it once and for all.
And come with your written notes also on the next day.
I
Only
had
thing is,
requested-
Mr. Mukherjee has to give the reply.
Once your lordship frames it, he has to first answer.
Yes, record and order. Learned counsels for the parties are present. Mr. Chatterjee submits on behalf of the respondent but could not conclude the submission. Thus, this matter stands adjourned for further hearing on.
As early as possible.
Yes, yes, I also want to.
And I finish it once. Just next week, 3rd, 4th, and 5th, my lord, I will not be available.
This first is also, first also you will not be available.
Can it be on 10th, my lord? 10th.
A little earlier than that, whatever. I don't have a problem.
হ্যাঁ 13 তারিখে 13 তারিখে দুটোর সময়
লর্ডশিপ বলছেন 13 তারিখ অসুবিধা আছে
13/8/2026 at 2 p.m. I have already made it part heard.
Substantial question.
Yes. Upon hearing the learned advocates and considering the facts of the case, this court is of the view that one more substantial question of law should be framed. Number 3. Was the evidence before the learned appellate court sufficient to come to a finding that the plaintiff respondents require the suit property for their own, reasonably requires the suit property for their own use and occupation. Acha, the interim order granted earlier stands extended till disposal of this appeal.
My lord can dispose of the application.
Yes.
Scan 7 can be
This application for interim order stands is disposed. The interim order shall continue till disposal of the appeal.
Much obliged. Much obliged.
So you submit and conclude on the next day.
Milord, that matter I had mentioned before, your lordship, Milord, where that 80-year-old person, Milord, his second appeal was heard by Justice Basu for about 2 years. Then, Milord, before...
Who is appearing for the other side?
There, Mr. Of course, he
I think that is not that Bashirhat that matter.
No, no. The file has come to your lordship's list. Your lordship
Which year matter?
A long time. Your lordship said, Milord, because it was heard at length. It was finished. Just that judgment could not be delivered by Justice Basu. It had to be heard again.
Anyway, let us see on the
Your
next
lordship
week.
said your lordship would place it on at to be mentioned.
So let it appear as to be mentioned.
Yes,
You
the
give the
file
slip.
The slip has been given. The file is here.
Okay, okay. It will appear as to be mentioned.
Tomorrow or day after, whenever your lordship.
To be mentioned, দিয়ে দেবেন ওইটাকে. You give the slip.
Which is রোহিত তুমি জানো তো এটা আমি মেনশন করেছিলাম, আমি দিয়ে দিচ্ছি, কার্তিককে বলছি দিয়ে যেতে। Lord, maybe take back the exhibit
yes,
list,
yes.
Lord, and we'll make a copy and give it to you.
Because after all, you have to prepare the written notes.
So grateful. So,
My lord, I am for the appellant in this case.
Yes,
This appeal of insurer, my lord, is a death case.
yes,
I've come up against an award of rupees 22 lakhs odd, my lord.
yes.
Lord, to cut the matter short, my lord, this appeal is only confined to the quantum of compensation. There are no other points involved. There is no cross objection. My lord, the deceased income, my lord, has been taken to be rupees 10,000 per month. He was alleged to be a driver. The driver in the year 2016, my lord, income per month 10,000 taken. On that basis, my lord, the assessment has been made. My lord, I have challenged this particular monthly income.
2010.
2016, my lord, 1/6. And secondly, my lord, again, my lord, confined to quantum only. My lord, deduction.
Yes.
My lord, the father of the deceased was made as one of the claimants here. The father of the deceased was made one of the claimants here so that the number of dependents can be, my lord, increased to 4 to take advantage of 1/4 deduction. Your lordship, my lord, is aware of, my lord has also passed judgment, my lord, father, otherwise, in absence of any contrary evidence shown, cannot be taken to be dependent.
Daughters, I have stated my judgment was.
Yes,
with
my lord,
regard to
married daughter, but the
daughters.
father also, your lordship is aware of Sarla Verma, my lord, and Pranay Sethi. Sarla Verma is very specific, my lord, which is backed by the 5 judges constitutional bench, Pranay Sethi, that unless evidence is to the contrary, father is not to be taken as a dependent. My lord, I need not elaborate on that. Other 3 dependents were there, my lord, deduction should be 1/3. Father need not be taken as a dependent, relying upon Sarla Verma, read with Pranay Sethi. My lord, these are the 2 issues. One is, my lord, monthly income 10,000 not to be considered, and deduction should be taken as 1/3, and not by way of a subterfuge, the father to be shown as a dependent, and then, my lord, the compensate deduction is 1/4 being made. My lord, I'll just indicate, my lord, the evidence what has been shown to you before the learned tribunal. May I, my lord?
Yes.
My lord, the widow of the deceased, my lord, has come up before the court as PW1.
Yes.
The page 7, if my lord kindly comes to, my lord.
Page 7.
Lordship. Page 9, my lord. After 6, it is 9. Page 9, my lord, it should be. The pagination is perhaps wrongly done. Your lordship will kindly, my lord, may I invite my lord to come to page 9.
Of the paper book.
Page 9 of paper book. My lord has got the paper book, my lord?
Yes.
Page 9.
Page 9, yes.
Lordship. My lord, this is the widow of the deceased.
Yes.
Deceased was 29 years old, my lord. The relevant part, my lord, what I'm going to show before your lordship is at page number 9, running page 12, my lord. Cross-examination at the bottom. Is my lord there, my lord?
Page 12.
Lordship. At the bottom, my lord, the cross-examination is there. My lord, this is, my lord, with regard to this 10,000 rupees income claimed.
Yes.
Lord, I did not see the accident. The next para, it is not a fact that accident cause was due to fault of fault of my husband. It is not a fact that my husband had no income of rupees 10,000. My lord, I have put in the suggestion whether your husband had the income of 10,000. My lord, why I say so? Because there are no documentary evidence here. Again, my lord, as usual.
Any driving license?
My lord, driving license is there. Driving license is there. And then, my lord, the next paragraph, I have filed no papers that my husband used to work with L&T. My lord, this was with regard to the income. Then your lordship will kindly come to page number 13. Page number 13, my lord, the allegation is, or my lord, the claim is the husband was used to work with this PW2, which is at page 13.
Employer examined.
My lord, employer is at page 13. I am showing to your lordship.
Yes.
My lord, this is the evidence of employer, PW2 before your lordship. My lord, may I read the first paragraph?
Yes.
The person died is Sahidul Rahman Malik. He was my driver. He used to drive my truck number so and so. That he used to work with us has no documentation. This is it. no documents. I was giving him 10,000. And my lord, in actual also, there are no documents that he was getting rupees 10,000 salary. So, my lord, therein, I dispute, my lord, whether this salary was 10,000 or not. No salary slip, no appointment letter, no khata, no bank account, no salary register, no pay slips. Absolutely, it's absolutely blank. 7 accept this statement. And I have, my lord, again put in a suggestion that you did not use to pay him rupees 10,000. It is at the bottom of that page. So, my lord, this is it. 7 accept these oral submissions. There are of the year 2016, your lordship will only take note of that, my lord. There is nothing on record which would prove this salary of rupees 10,000. This is first part. And the second part, my lord, there are 4 claimants, as I said earlier, my lord. The father has been shown to be one of the claimants. My lord, I had invited your lordship, my lord, to come to the evidence of widow. That is at page, my lord, page 9. My lord, your lordship will kindly, my lord, for my sake, my lord, come to page 9 again. The evidence of widow. Page 9, page 10, page 11, page 12 is the chief as well as, my lord, the cross. My lord, page 9, 10, 11, 12. Nowhere it has been stated that my deceased father-in-law was not working and he was dependent upon the income of his son. There is no line here. Only, my lord, showing him to be a claimant does not empower him, my lord, to be taken as a dependent to get advantage of 1/4. My lord, I am not saying, my lord, the calculation should be made differently, but you should not get 1/4 advantage just by, my lord, adding the number of, my lord, the claimants therein. Addition of, my lord, then he can also show, my lord, his mother-in-law, father-in-law, my lord, all cousins, all brothers and sisters, so that he can get 1/5. My lord, Supreme Court is very categorical that unless there is evidence to the contrary, father is not to be, my lord, taken to be as a claimant. My lord, I'll just read out that particular line. Sarla Verma is very specific, my lord.
Yes.
My lord, I'll just read one line. Sarla Verma. Further, subject to evidence to the contrary, not what I have stated, the father is likely to have his own income and will not be considered as a dependent, and the mother alone will be considered as dependent. In absence of evidence to the contrary, brothers and sisters will not be considered as dependents because they will either be independent and earning or married or be dependent on the father. My lord, I'll not trouble your lordship because this has been confirmed by Pranacity. My lord, these are the 2 issues, my lord, I've come before your lordship. First, my lord, monthly income, 10,000 need not be considered, my lord, for 2016. No documents.
Now, suppose,
lordship,
if we proceed on the basis of one third,
lordship,
how much it will be reduced?
my lord, it will very, very minor, my lord, because,
How much
my lord,
it will be
my
reduced?
lord, maybe, my lord, not more than approximately, my lord, the principal award is of 22,12,000.
Yes, suppose
They have
proceed.
My lord, I'll just indicate to your lordship. My lord, they have claimed 20 lakhs. I don't think it would go below 20 lakhs.
Now, that is what
Let me just make the calculation here. And
yes. Suppose we proceed exactly 10,000 and that 1/3.
My lord, 10,000. 2016.
Okay, 10,000. Suppose we proceed on 1/3. How much was granted? General damages?
My lord, general damages, my lord, was 70,000. तो आपने ये मेरा बोल क्या 70,000.
And future prospect?
My lord, future prospect.
I also can. Yes. Also granted.
My lord, everything else is correct.
Let us see.
There is no cross objection.
Let us see 1/3. Thereafter, I shall assert it. What is just and reasonable?
Madam, Supreme Court not permitted, my lord.
Yes.
Parents are entitled, my lord. It's in judgment, my lord.
So let us follow Pranay Shetty. Okay, that is the.
This and judge after the pronunciation, my lord. You can see, my lord.
No. After Pranay Shetty, you see.
Many judgments are there, my lord. You can see 1/4.
My lord, I don't say father is not entitled. Let him get, but you don't get advantage of 1/4.
Parents, my lord. 1/4 deduction, my lord.
Then there, my lord, the facts may be that the father has been shown to be a dependent. Here, not even one single line has been mentioned.
Legal depends, I can see.
You see, legal heirs is one thing and dependence is
Yes,
another.
I'm grateful to your lordship, my lord.
Mother-in-law, you can see it. Also dependent, my lord.
Here is a just calculation. Here, there is no ratio decidendi.
And you can see it, my lord.
Just a matter, you see, and
My lord,
calculation.
my lord. Justice Dipankar Datta also said, parents are entitled, my lord. Recent judgment, my lord.
Who is saying parents are not entitled? What is being submitted, my lord? I'm absolutely on a different footing.
Recent judgment, Justice.
Yes, give it.
Who is the driver, my lord? Para 3, action order 23. Para 4, wife to mind children and parents. Para 4, my lord. Para 16 is a driver, monthly income 10,000 per month, my lord.
You see, each case has to be decided on its own merits.
Para 4, my lord, wife to minor children.
My lord,
and
wife,
parents.
2 minor children and parents.
Yes.
Mother is one of the parent. So it would be 4 at least. Deduction would be 1/4. Addition of father would not make any difference, whether it is 4 or 5 or 6. My lord, all these judgments are irrelevant judgments here in the facts of the case.
My lord, para
Without looking at the judgment, I can not distinguish.
Para 30, that parents died during the pendency of the case, so no granted the loss of consortium. Para 30, last para. Para 30, last para. Consortium note that given all the claimants, but
13 is another. No, nobody is disputing consortium.
consortium, no, he is entitled, my lord. During the death, so not given the consortium. Now the question,
My lord, it is 20 lakhs.
20 lakhs. Just 1/3.
This is what they had claimed in the claim application.
Yes, this.
The Judge Secretary, please, Dinto.
Which paragraph you are dealing? Para 14.
It is 19,88,000 to be precise. Your lordship will kindly have a look, my lord. Just see.
19,88,000.
My lord.
General damages 84,000,
I have given
70,000.
70,000. I have given them 84,000.
Yes, take down.
Grateful to my lord, my lord. Extremely touched.
Learned advocates for the parties are present are learned advocates. The appellant before this court was a claimant in a case under section 166 of the Motor Vehicles Act 1988 and is aggrieved by the judgment and award dated 18/2/2025 passed by learned additional district judge, 4th Court, Barwan, district Purbo Barwan. Now it is Purbo Bardhaman.
Yes, my lord.
Earlier it was Bardhaman just.
Yes, my lord.
So in this way, Bardhaman district Purbo Bardhaman.
Yes, my lord.
The case of the claimants before the learned trial court may be summed up thus. On 1/10/2016 at about 3:30/4:00 hours, the victim Shahidul Rahman Malik was walking for his nature's call along the Kacha portion of Arambagh Barwan Road near Mughal Madi bus stand, and at the material time, a lorry bearing number WB 67 capital A stroke 3974 being driven rashly and negligently dashed the victim and then dashed against a roadside parked vehicle being number WB 39 stroke 6021. Stop. The victim sustained fatal injury and it caused his death. Stop. The accident was caused due to rash and negligent driving of the said offending vehicle bearing number WB-67 capital A stroke 3974. Stop. The victim is to earn rupees 10,000 per month being a motor driver and commission agent. Stop. Pursuant to filing of this case, notice was issued upon the opposite parties. Opposite party vehicle owner did not contest the case. Stop. However, opposite party insurance company contested the case. There are two insurance companies.
No, Milord, that's only
Yes,
national.
no, Magma,
Milord, I'm for the appellant Magma.
Magma, HDI General Insurance Company.
No, the award was passed against
Magma.
Okay, Magma.
Lordship.
The opposite party, Magma HDI General Insurance Company Limited, and because one vehicle was also dashed.
Lordship.
And opposite party.
That was Sriram, Milord.
Or Sriram General Insurance Company Limited contested the case by filing written statements. Vehicle owners likhe deben, huh? Stop. Issues were framed and evidence was adduced. Learned trial judge by
Milord, for Sriram, Mrs. Paul is appearing. Milord. Today, Milord.
Okay.
Lordship.
Anyway, his name can be recorded if he's there.
My lord.
Learned trial judge, upon considering the evidence adduced and upon hearing the learned advocates, was pleased to dispose the claim case by observing and directing as follows. The ekaneta quote. Page 48. Hence, the authority. The appellant Magma HDI General Insurance Company Limited, being aggrieved by the judgment and award passed by the learned trial court, has come up with the instant appeal. Stop. Heard learned advocate for the appellant and learned advocate for the respondent's claimants. Peruse the evidence adduced and materials on record. Learned advocate for the appellant submits that the learned tribunal erred in considering the monthly income of the victim as rupees 10,000 without any documents in this regard. Stop. Learned advocate draws attention to the evidence of PW3 where the said witness could not produce any document that the victim was his employer. It was his employee. Learned advocate also submits that the deduction on account of personal expenses ought to have been 1/3, as father cannot be treated to be a dependent. Learned advocate appearing for the claimants, respondent submits that the claimants have proved the income of the victim. Stop. Learned advocate further submits that that father of a victim is a dependent. Learned advocate relies upon the following judicial decision. Jyoti and others versus National Insurance Company Limited and others. Reported in Civil Appeal number 6209 and 6210 of 2022. Supreme Court of India. The next holo V. Padmavati and others versus Bharati AXA General Insurance Company Limited and another. Arising out of SLP within bracket C number 23880 of 2022. Supreme Court of India. Upon perusing the evidence adduced and hearing the learned advocates, this court is of the view that the claimants have adduced evidence with regard to the occupation of the victim as well as the income. Further, as the employer of the victim deposed in this case, it would be reasonable to consider the deposition of the employer PW3 that the victim used to earn rupees 10,000 per month. Stop. However, as the
Not employer is PW2.
PW3 na PW2. However, as the decisions relied upon by learned advocate for the respondents cannot be made applicable to the facts of the case, and in the case of Pranay Shetty, National Insurance Company Limited versus Pranay Shetty, reported in AIR 2017 Supreme Court 3157, father cannot be treated to be a dependent in absence of evidence to be a dependent in absence of specific evidence. This court is of the view that 1/3 should have been deducted on account of personal expenses. Stop. In the event monthly income is considered as rupees 10,000, the annual income comes to rupees 1,20,000. Future prospect of 40% being added comes to rupees 48,000, and the total annual income comes to rupees 1,68,000. Stop. 1/3 personal expenses deducted, net annual income comes to rupees 1,12,000. Stop. By applying the multiplier of 17, the total dependency loss comes to 19,04,000. Stop. Further, the respondents' claimants are entitled to rupees 84,000 on account of loss of consortium, funeral expenses, and loss of estate. Stop. Thus, rupees 19,88,000 is the total compensation which the claimants' respondents are entitled to by arithmetical calculation. Stop. However, this court is of the view that compensation of rupees 20 lakh is just and reasonable. Hence, this appeal, FMA 808 of 2025, stands disposed. Judgment and award dated 18/2/2025 in MSC case number 93 of 2016, passed by learned Additional District Judge, 4th Court, Barwan District, Purbo Bardhaman, is modified to the extent that the claimants' respondents are entitled to rupees 20 lakh from the appellant Magma HDI General Insurance Company Limited. Stop. The appellant Magma HDI General Insurance Company Limited shall deposit rupees 20 lakh along with interest at the rate of 6% per annum from the date of filing claim case till today before the Registrar General High Court, Calcutta. Stop. Such deposit shall be made within 8 weeks from the date of communication of this order. Stop. However, in the event the compensation awarded by the learned trial court is deposited, no further deposit be made. The claimant's respondents will be entitled to withdraw the compensation upon compliance of the necessary formalities. The balance amount, if any, along with accrued interest, be returned to the appellant insurance company.
Extremely grateful to my lord.
My lord, portfolio already paid, my lord.
Okay,
Speak itself, my
if it is enhanced, then the question of paying additional
Yes, my lord.
trial court fees, if not paid, be paid before the learned trial court.
Yes. Try to record, will be as far as possible as possible.
Acha, the trial court records be sent back at the special messenger cost of the respondents' claimants to be put in within 2 weeks.
Extremely obliged.
এটা rectification হলো।
On behalf of the respondents. Lordship, I am for the appellant. We are engaging through the High Court Legal Aid Service. Lordship, can 10 is my application. Appellant number 7 was expired on 2nd May 2026. We have filed a substitution application.
Can 1?
Can 10, Lordship.
Can 10?
Lord, kindly Lord allow it. And
Can 10 is for?
Lord?
Can 10 is for what?
Substitution.
Okay.
Lordship, one intelligence. Legal year of the appellant number 7, we are not collecting a vocalatnama from them.
Yes. You are representing whom?
Rest of appellant, Lordship.
Rest of the?
Rest of the appellants.
Okay. You have been engaged by?
High Court Legal Aid Service, Lordship.
For rest of the appellants?
Rest of the appellants.
So substituted appellants. Now, are you holding power on behalf of substituted this thing, appellants?
No, Lordship, I am not in power in the substitute appellant.
Thank you.
We are unable to communicate with them.
No, this appellant, you see.
You got it.
So far, this whole appellant died.
No, Lordship,
No,
no
no.
appellant died.
applicants are there.
Lord,
Already substituted.
Expired. 7.
No, item number 9.
9. Already substitution was carried out. Lordship, 7th appellant. Substitution allowed হয়েছে?
How many appellants were there originally?
7.
7. Out of which one appellant died.
Number
So leaving
7 was-
behind the other years who are already on the record. So no question of substitution. They are already on record.
Yes.
Simpliciter, the name can be deleted.
Deleted. Simpliciter. Lordship, led by Mr. Sanjay Mukherjee. For
Lord, kindly see, Lord, what happened. Lord, your Lordship knows your Lordship's judgment. Section 2G. Lord, a stillborn babe cannot be resuscitated to life. They have no right at all. Appeal should be dismissed in limine.
Right at all. That will be decided in after hearing them.
Lord, your Lordship.
But, why are you not ready today?
Lordship, we recently received the brief and
Directly
also we does not have all the copy. We does not have the
No
memo
paper
of
book
the
you have
appeal.
received. No paper book he has received.
Yes, Lord, kindly see my Lord's last order in the order sheet. Lord, kindly see our sufferings. They have no right at all. Your Lordship held that after death of the original tenant, in view of section 2G, the surviving sons and daughters have no right.
Dekhi last order ta ki ache.
Lordship,
My
officially
Lord,
we
sworn
are engaging on
observation.
23rd July. There is a legal aid.
No, when was the date fixed? 23rd July.
No, 23rd.
Lord, kindly 8th of July. Your Lordship's order, 8th of July.
No, when are you engaged by the District Legal Service Authority?
Lordship, previous engage.
My Lord knows Lord Rabindranath Mahato with Mr. Sonak Bhattacharya. All they have understood that there is
Now
nothing.
they have gone to the District Legal Service Authority.
Thereafter they have gone.
Last occasion they appeared.
No, you appeared on the last occasion.
Last occasion we are appeared.
Yes.
Dekhi record ta.
Mr. Tipal was there.
Sanjay বলছিল Sanjay leader.
Have you received the paper books?
Yes, Lordship, now we receive the paper book.
Today itself. Today you received.
No, Lordship.
You see, if you don't have any documents, you can ask your learned friend. He will supply you the documents. Any paper books, whatever it is.
Previously we engaged on 10th April.
Yes.
That date we are appearing all of the appellant. Thereafter, one of the appellant was expired. Fresh engagement was issued on 23rd July.
23rd July, you are engaged.
Yes, 23rd of July, you are fresh.
Let us see that.
Initially engagement April. After death, we have been asked to also represent the.
On last day, Lordship, we submit, one of the appellant was expired, there's a need for substitution.
That application is there.
That application was there.
Legal position, there is no substitution already on record. Nobody is left to be represented. He is representing the rest. This is not at all necessary. Totally, my lord.
Anyway, 23/7, he has received this letter. Let him take some time. Can you come on Saturday? This Saturday? First Saturday, 1st of August? 1st of August is a working day.
No, Lordship, Mr. Mukherjee was not available that day.
Oh, you are late by?
Mr. Mukherjee, Sanjay Mukherjee.
Huh?
Sanjay Mukherjee, Sanjay. No.
So if he is unable to come next day, you come ready so that you can argue the matter.
I prayed for 2 weeks of time.
My lord, repeatedly fixing date and time. Every time they are avoiding by changing their advocates. Earlier occasion, Lord, Mr. Rabindranath Mahato.
Now actually they have gone to the legal service authority. They cannot afford the advocates.
So long they had been affording. Only on the date of hearing they have.
Learned advocates for the parties are present. The application for substitution filed by the appellants is taken up for consideration. Appellant number?
7.
Appellant number 7 was
Not
died.
substitution, expunging.
Appellant number 7, what is the name?
Anita Ghosh.
As the appellant number 7, Anita Ghosh died during the pendency of the appeal, leaving behind the legal heirs who are already on record, let the name of the said appellant be deleted from the cause title. The department to carry out the necessary amendment within 1 week. Let this matter appear on 12/8/2026 at 3 p.m.
Not make it. My lord is there. Lord, kindly.
What can be done if they don't come on the last chance? They come with some exceptional circumstances. If they have some motive, you cannot prevent them.
Lord, his lordship is correct.
Yes, come ready.